Good morning, everybody. Can you believe I'm on time today? But I'm back at work, so we'll see how much time I get to talk and everything. But I got a lot of catching up to do. I've been gone for like 2 weeks, so bear with me. But I'll be on here off and on just to let everybody know I'm still here. So leave a comment, say good morning. But yeah, I'll be back. Hopefully there's no jury today. If I'm correct, there's no jury today. It's just the lawyers talking and everything. But still, I'm gonna keep it live so I can get me some view time. But we'll see how the rest of the day goes. So I will see you guys later. We might be getting started here soon.
All right, y'all come on up, please. And Miss, up to the podium. One of you can come on up and the other one can just sit in one of those seats right there till it's your turn. So you were Miss Borden?
Yes. Your Honor.
Okay. And you want to, what, live stream or what do you want to do?
Yes, I wanted to do a live stream in pictures and take notes.
Okay, well, you're certainly welcome to take notes. That is not a problem at all. In terms of live streaming, we've already got a lot of different cameras going, and so you are welcome to pull from either of the streams that's already occurring. All right? Okay.
Your Honor, I would like to, if it's okay, I would like to submit some reference letters that I have from a civil rights attorney and also the news media channels that I've been working with over a decade.
You
If I
certainly
can.
may, and it absolutely has nothing to do with who you are or who you represent or what you're going to say. It's just that we've already got so many pieces of equipment in here. It just becomes a kind of a security matter and a distraction to the deputies and frankly to me to have to keep trying to keep track of that many more pieces of equipment and people handling them. Had you been the first person, I probably happily would have given you the right, but it's just, you know, we've already kind of got everything set up. There are two different streams that you can pull from. So yeah, I'm happy to take them. That's not the reason for the denial. It has nothing to do with who you are.
And can I say something, please?
Sure, absolutely.
So my concern up under the Rule 2022, and I've been doing this over a decade as a civil rights leader, and also an awarded community advocate for our former mayor. So I am aware that there are other cameras, but with the case of this nature, I feel like the community deserves different angles and different perspectives. So while they do have a camera and while the camera is on, there's still different perspectives and angles. That footage goes through some other entities that I'm not a part of. So even if I was to pull or jump on their train, that is separate from me as a civil rights leader and wanting to share with the community and making sure that it is a fair trial.
Okay, so I don't know if you mean angle as in position that you would take in your reporting or angle as in camera angle.
When I say angles, meaning that, for example, there's a camera on right now.
Right.
That I'm looking at. So if I want to report something or show something and it's not from his angle, that means if I have to jump on what he's doing, I'm relying on his footage only.
So you actually literally mean camera angle.
Yes.
Okay,
Yes,
which
camera
is
angle.
either gonna be
Yes.
on the witness, the judge, the state, or one of the defendants.
Yes, but it's still the reliance of me depending on the footage. And I'm pretty sure the footage that they have, I know any other time I've worked with 2.5 and 1146, there's an approval process for that footage. And I will also be dependent on that sometimes as well. But if I'm able to stream myself, then I have more control of that footage.
Okay, well, if you want to go back in the media room and film from there, you may do that.
Okay.
Okay. All right. All right. Anything else?
No, Your Honor.
Okay, thank you. All right, and Miss Hall. Good morning. How are you?
Good morning. I'm fine. Thank you for your time today.
Sure. And you want to do still photography and
Yes, ma'am.
audio?
Yes, ma'am. My situation is a little bit different, even though I do have a YouTube channel and I can pull from the pool, which
Right.
I have done.
Okay.
Because I'm a freelance blogger, I can't depend on the pool for still images. So my situation wouldn't be setting up tripods or anything of that nature. And I would ensure the integrity that I'm according, especially from our seating that we have, that we don't compromise any integrity of jury or anything of that nature.
All right, and you'd be able to, you say still photography and audio, you'd be able to pull audio from one of the
I can
pool
pull,
sources
yeah, I can pull
already.
audio from pool.
Okay. And what kind of equipment are you talking about?
Sony AX50, one of those type of still cameras.
Does it make any noise?
I will make sure the settings are off.
All right, you're gonna need to be wherever it is that the deputies put you,
Yes,
and
ma'am.
you're not gonna be able to move around.
Yes, ma'am.
Okay. All right, and what's the camera?
I have a Sony AX1, Canon C50. So I'll work with the settings and make sure which one will be dependable on the fact that it will make no noise.
All right, and you'll be the one operating?
Yes, ma'am.
Okay, thank you.
Thank you.
All right, Ms. Abbasi, did you just get alerted this morning that you were gonna be the one covering court?
Is it granted?
Yes.
Okay,
We'll
thank
get the paperwork out to y'all probably sometime today.
Okay, thank you so much.
Okay. Well, since you didn't know until, I guess, a few minutes ago, nothing you can really do about it other than get here as soon as you could. So I appreciate you doing that. All right, does anybody have an issue with anything that occurred over the course of the evening that y'all need to bring up with me? Or is everybody fine? Yes, sir. Well, Mr. Sharp stood up first.
Your Honor, we came in today
Good morning, everybody. So we're just waiting. I missed what happened. Trying to catch up on my work, but hopefully they're just on a short break, even though they just started. But hope everybody's doing well today. And what I'm gonna do is I'm gonna go and look, see what happened, and I will come back.
To provide me with anything you found between yourself and any of the attorneys for co-defendants who have entered pleas?
Judge, the court gave me until noon. And
Oh, okay, that's fine.
Your Honor, I would like, with permission of the court, to check with Ms. Winfrey's exhibits to see that 460 is up there, because I took one stack, but
Okay.
460 was not.
You can check.
Thank you.
And were the parties able to come to any agreement or partial agreement with regard to any of the exhibits that were tendered at the end of the day yesterday?
No, Your Honor,
Y'all haven't what?
we haven't discussed that, redactions. I have gone over the exhibits themselves, and I have a legal argument that I'd like to present to the court regarding 104.
Well, I'll hear it after lunch then, because I instructed you to get with the defense so that you could see whether y'all could come to any certain agreement. So if they haven't seen it yet, then I will give y'all the lunch break to accomplish what you were supposed to accomplish yesterday evening.
And may I inquire what the court inquired, whether 460, which was a document that I believe at the end of the day,
Mm.
some counsel for defense was looking at, I believe that I retrieved it, but I think Mr. Sharp may have had it.
I don't know. Does anybody have 460Y? Can y'all check? Sometimes it's hard to keep track of all the documents.
Now, there was several documents that someone, I think it was either myself and Mr. Adams, put into the documents, that folder for the documents.
Identified only.
Yes, identified only.
Yes. All right. Do you locate it? Were you able to locate it, Ms. Love? Okay. Well, I'd imagine that would be easy enough to reproduce. It was just printouts from emails, right?
It was rights emails. And we provided a hard copy.
I mean, yeah,
And actually,
I'm sure I have a copy of it since you gave it to me, if that would help.
it would, if the court doesn't mind allowing us to copy, court's copy, I would.
Okay.
Return it back.
I don't think I've made any markings. Well, I have made a marking on it, sorry.
It would actually help us to recreate it.
Just, yeah, look at it to recreate it, that's
Yes.
fine.
Thank you. Thank you very much. Thank you.
Nobody was able to find a 460Y anywhere? Okay. Has anybody checked up in that podium area? Okay. All right, well, it can be reproduced. It's not the end of the world if we can't find that particular one. All right, turning to the issues we need to decide. Ms. Abbasi, your co-counsel had filed a motion in limine regarding autopsy photos from the Holmes murder. Is the state ready to respond to that?
Yes,
All right. And Ms. Abbasi, do you want to make any argument?
At this point, no, Judge, the motion is largely self-explanatory.
All right.
I'll let Ms. Sullivan.
Thank you, Your Honor. Good morning.
Good morning.
Your Honor, when we get to presenting this act, which is count one, Act 79, the state intentionally did not include the medical examiner. This is a case in which Mr. Ryan has been convicted of the murder of Jamari Holmes. And so it is only the state's intention to bring in 3 photos, and I have a copy of those 3 photos that I can show Ms. Abbasi
All right.
through
Well,
the lead detective in order to minimize that level of testimony. And so we do not plan to stipulate, but we've selected only 3 photos that we intend to
all right,
introduce.
let's see what they are.
And I can bring them up to the court. For the purpose of this hearing. Yes. And for the purpose of this hearing, Your Honor, the state's gonna label them states 1 RR, states 2 RR, and states 3 RR.
And what do y'all plan to present with regard to, I mean, just kind of a general overview, the evidence that will establish that Act 79?
Generally, Your Honor, what occurred leading up to the homicide of Mr. Holmes, which was a luring of Mr. Holmes to an apartment complex that Mr. Ryan and Mr. Blaylock then, we believe, ambushed Mr. Holmes along with 2 other victims. They were in a vehicle. Mr. Holmes was shot, and then they fled. And then subsequent to that, there were Instagram postings, Facebook postings, or excuse me, social media postings regarding YSL, very close in time to the murder of Mr. Holmes, Your Honor.
All right, and how many witnesses are you going to utilize?
For that act, so we have 5 witnesses.
Who are they? And what will they generally testify to?
You know, that 5 is a marked reduction from the original list of witnesses. We did not intend to retry that murder.
Well, that's good to hear.
Your Honor, 5, the witnesses for that act are Ms. Sharon Latner's, Starry Holmes, who's the mother of Mr. Holmes, Mariah.
An eyewitness?
No, she is, just would be able to bring in his in-life photo.
Let's
And
figure out
talk
a different
about
way
Mr.
to do
Holmes.
that, especially given that this is not even the trial of that case.
And speak about Mr. Holmes and who he was. Okay.
I have a relevant suggestion on that.
And that would be sustained.
And to talk about his involvement, who he is as a, prior to this murder happening, he was a juvenile. I don't know if any of these other witnesses would be able to do that. Mariah Smith was someone, I believe he had just met recently, who helped set up the robbery that ultimately led to his death.
Okay, all right, have you moved on to another witness now? Is Mariah Smith another witness or?
Mariah Smith is another witness, Your Honor.
So Mariah Smith would be able to say he was a juvenile, right?
She doesn't, I don't believe she really knew Mr. Holmes.
How old was he?
substantially. He was 15 at the time of his death.
Mhm.
Yes.
And Miss Latner's backing up, she would, what, introduce a 911 call?
Yes,
And what's that gonna say?
But it was the initial reporting of the shooting. So it was at the time, the time of the shooting.
Just
Framing
one
the date.
call?
Yeah, I believe just one call, Your Honor.
Judge, we would have no objection to the call.
Okay.
Admitted where, the witness says he'd like to speak with police and police don't speak. So we have no problem with that call coming in.
Is that the call?
I don't think that that's the call. I think that the initial call about the shooting.
That may be a different call.
Yeah.
It's a different call.
Okay.
And
Okay,
So
so,
the witnesses are our skeleton version of what we can present to show absent, because we cannot just put in the certified to show the facts of the case. So we're trying to put in.
well, I mean, sure, the fact of the murder wouldn't get it as an overt act that is a part of RICO. So I understand you need to do a little bit more than that.
Right. And so we're trying to, we've scaled back. We had these
Okay.
witnesses.
All right, I don't
represent
need to
one of-
hear what it was gonna be at one point in time. Maria Smith is going to say what?
She was one of the 2 young ladies who lured Mr. Holmes and his 3 friends back
Okay.
to the location, or to the location.
All right,
Then we have one of the two other victims. We don't plan on calling both of them.
Okay,
So that it'd be either Mr. Uten or Mr. Mitchell.
all right.
Then we have the lead detective on the case, who is Detective Hogan. Then we have Mr. Mike Sprinkle, he further brought the
He'll-
additional evidence of some of the social
Social
media
media.
that came in later. And then last, sort of,
So 7, not 5.
so Rooney Lee is one of the co-defendants or co-conspirators in this case. He is coming in during this portion, but he was present during the initial trial of Mr. Ryan and posted some social media postings with rat emojis when Miss Mariah Smith initially testified in that trial. And so he's coming in that portion, but he's not actually a part of what will prove the actual act, but that's why he's included.
And Your Honor, we do need some clarification whether it's going to be Mr. Uten or Mr. Mitchell. We've been in contact with the state about going through the evidence offered for these witnesses, what does or does not need to be redacted. Mr. Uten's interview is maybe about.
Can y'all spell that last name?
Yes, Your Honor, it's OOTEN.
Okay.
His interview is maybe about 20 minutes, half hour with some quiet time, and Mr. Mitchell's interview is several hours long.
Okay. When are we going to get to this part of the trial?
Your Honor, we would believe that we would get to this portion of the trial probably early October,
Okay, so fairly soon.
fairly soon. Yes,
All
Your
right,
Honor.
when will y'all know who it's going to be?
We should know within the next few weeks, within 2 weeks, Your Honor.
Your Honor,
Well, 2 weeks from now is the end of October, so, I mean, the end of September. Trying to rush that along.
Your Honor, we do want to have an opportunity to go through the state what evidence they believe will actually be admissible. Right
Okay.
now, we've got more than 50 pages of Instagram reference from Mr. Blaylock, co-defendant not testifying, more than 200 pages from Mr. Ryan. Those are obviously issues we'd rather not sit down with the court and go page by page, but if we need to, then we will.
And Your Honor, I believe there was some preliminary conversations, and we do intend on furthering or finishing those conversations with Ms. Abbasi and Ms. D. Williams.
Okay, well, that probably needs to get done before the end of next week.
The state could respond to our email. if we want.
Can y'all,
We can. We've also found it fruitful to communicate via phone, which we have done and will continue to do at times that are convenient for either Mr. Abbasi or Mr. Williams. That communication has not stopped. I think there were some issues, but we've done that as well.
all right, well, try to do it in a timely manner, please. Okay, let me see the photos. And the photos would come in through the detective. Did you get copies too, or are we just? Is this third one like post incision, or is that the exit wound?
That is the entrance wound. Your Honor.
Entrance wound?
Yes, Your Honor.
Your Honor, one of our objections is I don't know who's going to be able to answer that question. I don't believe the lead detective is qualified to explain what type of injury you're. We don't believe the detective will be able to lay the foundation. Oh, I'm sorry. We don't believe the detective will be able to lay the foundation for these photos.
All right.
We believe that with some conversation, he can talk about the fact that the victim was shot in his head, that is the victim, that it was his homicide that he was investigating. The picture, which I believe is 2RR, with just the area in which the
Before it's shaved.
before it's shaved, I believe that he could talk about where the bullet was, or that he was shot in the head. And then the last photo, I'm not sure if he'll be able to say it was an entrance wound. We'd have some further conversations with him regarding whether or not he was present during the autopsy or not, and whether or not he
Do you think that there's any chance he was present during the autopsy?
Some have, sometimes they are. Sometimes they are. I'm not saying that he would, but sometimes they are present during the autopsy.
Was he present at the scene before the body was removed?
Yes, Your Honor, I believe so. I believe so, but I need to ask. Ms.,
Okay, well, you'll,
Ms. Love. Do you know if he was present?
Your Honor, I've got, based on the police report, the officer received his phone call at 6:07 requesting assistance to the homicide. The victim had already been taken to Grady in ambulance 571. He was pronounced dead at Grady at 6:10.
okay, so if he was at the scene, he wouldn't have seen the victim at the scene, so that wouldn't be helpful with regard to these photos.
And Your Honor, we were trying to avoid the ME, so if we can have some stipulations to that, or we can have the ME come in for
All right,
innocent purpose.
why don't y'all get together? I'm gonna hand these back for now and come up, maybe you could come up with all sorts of stipulations. So we'll revisit that.
But we are just trying to reduce the need of having to call the medical examiner.
Say that again.
We are just trying to reduce the need of having to call Dr. Sullivan.
Well, there's no necessity to call him or her. Can't remember. Thought so. Okay. Yes.
On that, I'm not saying I cannot find my list. I cannot remember if the state is moving for the verdict against Mr. Ryan into evidence, but I would be objecting under 24-8-803-22. And I'm just reading from a case, a jury's verdict that the co-defendants were guilty as a hearsay statement. The exception to the hearsay rule provides for the admissibility of the final judgment of guilty as to a felony, but not including when offered by the government for purposes other than impeachment, judgment against other persons other than the accused. And then I just pulled up 24-8-803, and then it's subsection 2.2, and it specifically says the same.
What's with the state's plan with regard to that?
I just want to put you on notice so we don't go into it.
As to the conviction itself, Your Honor, I believe that it would not be improper, and I'll reread the case law on that. I don't believe that it would be improper to limit, as the court did earlier with the conviction itself of the witness. Actually, because it was not a statement that he made, actually, Your Honor, I think that it would be admissible against all of them. It wasn't a guilty plea, so it's not a statement that the
It's any judgment of previous conviction is what 22 covers.
okay.
So
So to the extent that the actual certified is tendered, then if it is the fact, and it could, we don't argue that it, it's probably the fact that that certified alone is admissible only against Mr. Ryan. But the facts of the murder itself and the circumstances and what he did, we'd argue are admissible against all of the defendants in this case. So,
the facts,
yes.
right.
Not the actual certified, but I was speaking Ms. Hilton, not the court.
I can't hear you. I mean, I know that that mic doesn't want to behave properly, but maybe you can borrow the witness stand mic if that one was even working yesterday.
It wasn't. I'll try to hold it carefully. So the certified itself, we may have no argument regarding that being used and there being a limiting instruction as to the certified itself against Mr. Ryan only. But we would also ask and would craft and present to the court an alternative if there is an instruction that is requested that includes language that the facts that are presented that the jury takes as evidence are admissible against all of the defendants, including any postings or statements that Mr. Ryan or Mr. Blaylock made as a result of or in furtherance of that act.
It seems, Your Honor, as well, that while the court can't hear us,
It seems that while the court can't pick us up, somehow or another, the person who is running the camera, he hears all of our.
All right, well, I have,
He's asking
that
us
is
to turn it off.
irrelevant to me.
I know.
I mean, I'm not worried about how the media can or cannot hear. I'm worried about whether the parties in this case and the court and the jury, when the jury's here, is able to hear.
Yes.
So they'll just have to deal with it.
You're-
because the issue was they could hear our internal.
Oh, they can hear what y'all are saying there at the, so that's getting picked up?
Yes.
Well, that's problematic.
With all the mics off.
Okay, so y'all gonna need to adjust your microphone in a way that is not picking up attorney work product conversations. Can you do that?
We just get the feeds from the courthouse.
Okay, well, then you're not gonna be able to to do the audio if it's picking up attorney work product conversations between the counsel at the tables. I don't know what to, I mean, some adjustment's gonna need to be made. I doubt if they can hear it all the way over there, but what all's getting picked up?
Just when they were having a conversation. I turned
The
it off.
state,
I turned the audio off. When I heard it. Whenever I hear this.
well, I appreciate that, but I'd imagine it's gonna be pretty constant that they're gonna need to talk amongst themselves.
And it's happened multiple times in trial that people will text us, they can hear your conversations at the table. So this is a repeated issue that's been.
Okay, well, thank you for bringing it to my attention. Where's your feed, like your audio feed coming from? Where's it getting picked up from? Do you know where the mic is?
No, it's connected to the court system. So whatever you are,
All right, Ms. Persfield, can you get IT to get on that issue, please? She's watching on the Zoom, I assume. Maybe I should text her too or email her too. Instant message her on my computer. Give me just a second. So you're attached to what, the Zoom?
whatever feed the court gives.
I don't know what feed the court gets, but all right.
I run it when the court can't hear.
All right, Ms. Pursfield's reaching out to IT about it now. All right, do we want to turn to where we left off when we were last here, which was trying to sort out the nested hearsay in one of the wiretap conversations?
Your Honor?
Yes.
Before we turn the page, could I just get some clarity? Because I'm confused. The state, I believe, indicated that they thought the facts of the murder case involving Mr. Ryan were admissible in this trial, but the conviction wasn't. But then they started talking about limiting instructions.
Mhm.
And I'm confused. Are they maintaining that the jury verdict from a separate jury is admissible against in this case? Or are they abandoning that and saying that they're going to get into the facts of this case?
Go ahead.
We are saying, Your Honor, that the conviction itself is admissible and will be tendered, and that an instruction should be given that the certified that we intend to introduce that conviction should be considered against Mr. Ryan only.
Oh my.
But the facts of the murder and what happened should be considered as evidence if they choose to, believe it, against anyone currently on trial.
All right, so it sounds like
Well-
you do intend to introduce the certified copy of the conviction,
Yes, Your
and
Honor.
that would be accompanied by a limiting instruction that is probably similar to the one I gave before, that that can only be considered against Mr. Ryan. Of course, he's charged with the RICO count, right?
He is.
Okay. And then they would present facts which they would hope to be able to establish not only that a murder occurred, but that the murder was part of the RICO conspiracy.
We would
And
introduce.
that would be admissible against everybody charged with the RICO count.
We would, right, much like some of the unresolved murders that are in the indictment. We would be introducing the evidence that Mr. Ryan and Mr. Blaylock did it, and what connection we believe it has to YSL, and what they did to promote YSL before, during, and or after. So that evidence we believe is admissible against, well, we know it's admissible against everybody on trial now.
Okay.
All right, does that clarify?
Well, it clarified that we do not have an agreement, and I'm diametrically opposed to what the state is saying. Couple things. First of all, that verdict was not the verdict of the fact finders in this case, which
Sure.
we chose and are our jury, and that's Mr. Stillwell's jury.
All right.
Also, Your Honor, I'd like Your Honor to know that Mr. Ryan's case is currently on appeal. It's not a final judgment, it's on appeal.
All right.
And I guess I defer to Mr. Attorney Steele on this, because as I understood it, he was going through the law that would prevent them from presenting this as evidence. And it is evidence against us.
I'm sorry, when you say this, what do you mean?
The
fact of
conviction.
Conviction?
I'm not worried about the facts. I understand the facts, but the conviction, and they want to use it as proof of an overt act, which as an
Only
element.
as to Mr. Ryan
Well,
is what they're saying.
well, no, they just said it against everyone as far as count one to RICO.
The facts that they're going to present, not the conviction.
Okay, well, I don't, as I understood the case law as Mr. Steele was reciting it, and maybe I'm wrong, but I thought we were at an understanding that they could, that's exactly what they could not do, is take a verdict from another jury and use it as substantive evidence against anyone in this case.
No, they can use it against, I think that they can use it against Mr. Ryan.
Well, they're using it against him for a RICO. This was not an admission by Mr. Ryan. This was not a plea of
No,
guilty.
he was found guilty. It's still a judgment of conviction.
Well, it's not a final
And-
judgment. It's on appeal.
Pendency of appeal doesn't matter in terms of admissibility. It's right there in the statute.
Okay. Well, I understood the state said two different things, and so I was seeking clarity. I'm opposed to it. I'm stating my objection. I don't believe that if Mr. Ryan is charged with a RICO count along with my client, and they have the exact same element, and the jury's instructed that they need to find the commission of one of the overt acts, and they're told to consider the jury, the finding of a jury, a separate jury against Mr. Ryan. I don't know how they separate that. I don't know how a limiting instruction separates that and protects Mr. Stillwell's rights, and they wouldn't accept that same jury verdict against Mr. Stillwell and others for count one. I don't think a limiting instruction would be sufficient. I think they need to prove that case.
I think we have some case law that addresses that subject. I'd like to flesh it out, given Mr. Sharp's objection, but I'd preliminarily point the court to United States versus Pelullo, Pelullo, 14 F 3rd, 881 at 888. It's a Third Circuit 1994 case. And it specifically speaks to prior convictions being routinely admitted into evidence at subsequent RICO trials as an ordinary piece of evidence. A judgment is subject to evaluation by the
Slow down a little bit.
Oh, I'm sorry.
A judgment what?
As a judgment, I'm sorry, as an ordinary piece of evidence, a judgment is subject to evaluation by the fact finder, who can accept or reject such evidence as it deems appropriate. Also, United States versus Tocco, Tocco, 200 F 3rd, 401, in site 417 to 418. It's a Sixth Circuit 2000 case, finding the district court's admission of evidence of a co-defendant's prior conviction permissible to establish RICO predicate. Here it says because the evidence was not used as collateral estoppel, but again, these are cases that I would need to flesh out. These are just preliminary cases for the court's consideration, given the argument that I'm hearing Mr. Sharp make right now, that we would point to as a starting point.
All right. Well, we're gonna have to get that sorted out fairly quickly if we think that within the next 2 weeks, we're gonna get to this,
Yes, yes.
or so, 2 weeks or so. Okay. So, Mr. Shar, are you clear at least on what the state's position is?
Now,
Okay.
thank you.
All right, we ready to turn to that Garlington wiretap? Hmm? Oh, yeah, I'm not deciding that issue right now. We'll come back to that. Sure. Evidence before the Garlington wiretap evidence? Okay, then maybe we need to set aside the Garlington wiretap and deal with the evidence that's gonna come in against Ryan. Okay. We'll wait till he gets back, but just trying to figure out which thing to turn to next. Okay, that's fine. Let's take a quick break for anybody that needs to run to the restroom. Maybe we should turn to the evidence that's gonna come in on Mr. Ryan's, on that. That'll happen before the wiretap evidence.
Yes, Sharon, I thought, are you talking about the email that Miss D. Williams sent?
I don't know,
Because
did she send one recently?
I thought Ms. Abbasi and I, that was what we talked about a few moments ago. You said, the two of you need to get together by the end of next week to go through those items so that we wouldn't have to use the
Okay.
court's time to do that.
So I guess it was, yes, Ms. DeWilliams' email from, well, it was a long time ago, about all of the exhibits.
Yes, Your Honor, and
Okay,
I'll
so
get with
y'all
Ms.
will get
Abbasi
together on that.
yes, to discuss a time.
Okay, and can you remind me, did the state decide that y'all can, I guess, concede that Mr. Ryan's statement to police is inadmissible? Or no?
Yes, we can't use that.
Yeah.
Okay, all right. I thought y'all had conceded that, but I hadn't written it down on this. So. Let me put that in the issues that have been dealt with folder. All right, so do we want to do,
We could talk about the busing stabbing.
the what?
One of the matters that were addressed in an email by Mr. Ryan's counsel was the Harold Bussey stabbing. I believe Mr. Abbasi or Mr. Williams moved in limine regarding excluding the evidence that Mr. Bussey was stabbed. Our argument about it being intrinsic, the court last said, or gave Ms. Abbasi an opportunity to give case law stating that things that were used after the fact, Ms. Abbasi can correct me where I'm wrong, but acts that occurred after indictment could not be presented. And I think in her brief, she indicated that, I don't want to speak for her, but I think she indicated that she found no case law in support of that position. So we're prepared to argue
Okay.
that. I'll let her speak.
Yeah, we submitted a brief and went through each of the possible admissible purposes. And as far as completing the story, something which happened after the indictment was following there. However, something which after indictment certainly could be part and parcel and inextricably intertwined in the same facts and circumstances, but that's not this case. So the brief does put out in there that the intrinsic facts the state is seeking to admit does not meet any of the criteria or exceptions, whatever you'd like to qualify it as, for those acts to be admitted. I don't know if the state is planning to respond. I did submit that several weeks.
Right, and I read it and I marked on it, and now all I need to do is find it. I need somebody to keep me organized. Does the state have a response?
We do, and
Did y'all file a response?
No, we made an argument that essentially is the same one we're gonna make today, but based on what they've put forth, we'll respond specifically to the arguments that are asserted, put forth in Ms. Abbasi's brief. I think we presented case law, and I think that the court saw that case law. I won't speak for the court, but I believe the court saw and was satisfied that the case law does say that acts occurring after indictment are not precluded as evidence of the conspiracy.
Right, no, agreed, but it's two separate issues. I mean, if it's gonna be, they're not precluded just because they're post indictment, but if they're gonna be admitted as intrinsic evidence, then they have to fall within one of the things that makes them intrinsic evidence, that it's the same series of transactions, it's necessary to complete the story, or it's inextricably intertwined with the evidence about the charged offenses. So what are y'all contending that it is?
All of them. So inasmuch as the arguments that are put forth in Ms. Abbasi's brief seems to focus specifically on
Your Honor, if I write that, I don't think there is a focus. I've never heard them say which theory they're proceeding under.
Right, yeah, you're saying it's not any of them.
Correct. I've never heard them say which of those three it's specific are.
So, Your Honor, I'll just tell Ms. Abbasi in the court right now. It is intrinsic to count one. Additionally, the conspiracy that it also is a part of is the YSL gang itself and the conspiracy that the gang itself makes up. I think we already presented some of the facts of the case to the court regarding the in concert action by five YSL members and two others of stabbing one person in defense of Mr. Ryan. And I know that the court has already read the indictment that describes, as the state alleges, the conspiracy itself being preserving, protecting, and enhancing the reputation, power, et cetera, of the enterprise through acts that include assault and threats of violence. And of course, I'm not reading the entire indictment, but in this particular case, it falls squarely under a number of actions that are intended to sort of circle the wagons around YSL members, show that they will stand up for each other and that they will commit violence on persons who they perceive as threats to members of YSL. Mr. Ryan, after he was indicted, there were several, at least one YSL member that we have listed as an overt act who makes assertions about Mr. Ryan and his murder charge and subsequent, I think, conviction. And there are people who perform acts during the course of his trial, or at least one person that we believe were intended to intimidate a witness who was actually on the stand at the time. There are, by way of examples or analogies of other similar acts that are committed on behalf of YSL to show their solidarity. For instance, when Mr. Garlington is jumped, other members of YSL immediately jump in. We have evidence that when Mr. Copeland is jumped, at least one person in the courtroom now jumped, just jumped in just because. When it's one of them, they're going to come to their defense. The act itself was.
Hear all of this argument, it'd be great under 404B. Waiting to hear which of these three categories it falls into. We're talking about two different issues here. Which of the three, and then 404.
It is not 404B, it is intrinsic.
It could be both. I mean, I guess it would be intrinsic, but I mean, y'all haven't offered it as 404B, right? And you don't intend to,
Right.
even if I rule against you on the intrinsic.
Well, if the court ruled against this, it would be a different argument that we'd be prepared to make on a different day, because that's not something we're putting before the court
Okay.
today.
All right.
So the actions of Mr. Ryan and the other YSL members in concert in stabbing Mr. Bussey, when Ms. Abbasi asserts that they're not necessary to complete the story of the crime, this is our position, is that this conspiracy didn't stop at the jailhouse doors. It's ongoing. It's necessary that the jury sees that it is ongoing to show to them the truth and the whole truth that we believe that our evidence reflects, to show them the extent to which YSL members go in order to preserve and protect not only their name, their own, but their reputation. Mr. Ryan, Mr. Blaylock, Mr. Eppinger, Mr. Myrick, and Mr. McMullen are seen in the photo that, I don't know that the court needs to see it, but if it does, we can present it on Zoom camera to show the concerted action on their part in stabbing Mr. Bussey. This particular screen grab of the video doesn't have 5 knives in the air like one of them does. This was just them all holding him down. And for the purposes of just this hearing right now, we'll just call it State's Exhibit 465, RR for rebellious Ryan.
All right.
Your Honor, I guess I'm kind of more confused now because I think the state's purpose is they want to show that it's ongoing. So I don't know how they're using it to complete the story of the crime if their version is that it's not complete and it's ongoing. I don't see how those two square. It's not an element that the jury has to find. The gang is continuing. The only thing they need to prove is that by the date of indictment, this happened. It really doesn't matter as far as what the jury needs to know to, for the state to meet the required elements. It doesn't matter whether the gang is continuing.
All right, but the state can prove if it chooses
They sure can.
that it's an ongoing conspiracy.
Sure, but that doesn't make it necessary to complete the crime.
Well, necessary to complete the story of the crime. And I guess the story of the crime is
Ongoing and continuous conspiracy that is YSL, its enterprise, and the members committing these particular acts and crimes for the purposes listed in the indictment under the definition of the conspiracy itself. And this act is not something that is obviously relevant to the issue of whether or not the defendants are or are not guilty of count 1 in terms of what we're alleging that they conspired to do. It certainly would be an overt act under the definition of overt act of count 1. So it would go to prove count 1 as to each of the defendants. It's therefore relevant, highly relevant as to that particular issue. It's presumptively, of course, the court is the gatekeeper, but under 402, because of its relevance, it's presumptively admissible. Under 403, Your Honor, there's nothing about it that is so substantially more prejudicial than probative, given its highly probative nature. Do we have the Zoom up here? Can we pull it up and put it on Zoom? Considering it's coming just, we can't, we're not in yet.
all right. Ms. Abbasi, can you remind me, and I don't know which one of y'all cited Murphy. Was that you, Ms. Abbasi? The part about integral and natural part of the witness's accounts of the circumstances surrounding the offenses, which factor did that go to?
I specifically did not cite that case. I did discuss whether it would be integral, natural far as what happened, I didn't cite him or.
Okay, well, maybe it was just one I,
I did want to touch on one thing the state said, because I think we're getting into dangerous territory. The state said that this act in and of itself could constitute an overact to support the verdict. Well, now we're talking about trying to prove the charges against the defendant based on something not in the indictment.
well, and you know, that's an issue that I've got written down here as something that y'all owe me law on, whether an overt act not listed could be the sole basis for a conviction.
Right, we do, and I think at some point.
Still waiting on that law.
No, we actually, I think at some point, and I might be wrong about this, but a contrary position was presented and whatever case was cited, did not support that position. And we have affirmative, case law that we present in the form of a brief to the court.
All right, well, you go ahead and get that filed can you get it filed? When can you get it filed? By Monday?
Monday is
by
better.
Friday?
Monday is better.
All right, by Monday.
Your Honor, I can get to the court kind of the contrary case law, but in the appellate, I know it sounds kind of, doesn't sound to square up, but it leads to an inconsistent verdict that perhaps some of the jurors found the defendants guilty based on the acts which were in indictment, and perhaps some of them found the defendants guilty on these
Oh.
acts which were not in indictment.
I mean, it's gonna be real fun when we get to the verdict form. I think that we're gonna have to get really specific about what they're finding.
And so
Because
that's
I don't
just-
think it can be that 6 found one and 3 found another and 2 found a third.
I think that this case, this situation, this precise situation came up in Cotman, and I could be very, very wrong. I read it, I glanced over it briefly. But I think that the court found that, given that the court instructed the jurors that their verdict had to be unanimous, that it did not present a reversible issue. The defense argued, or the appellants had argued, that there was no way to tell whether or not they all agreed on the same overt act. But in giving the court the brief that we intend to present, I think we can address that as well. I think that that part is easily
All right, so
addressed.
that'll be 2 different issues. Can an overt act that's not listed in the indictment be the basis, the sole basis to support the conviction?
Mhm.
But then there's also, does the jury need to find unanimously this overt act, specific overt acts? Do they need to delineate which overt acts they are unanimously finding exist to each defendant?
Right, and I think that as it relates to our previous discussion that the court said we would address a little bit later, whether we number them or whatever, I just off the top of my head, I think that them listing an act that they found unanimously had been committed as to the defendants, I think would suffice.
Okay, well, if we all agree on that, then we don't need a brief on that.
Okay,
Judge, with this
so,
issue,
I'm sorry, Mr. Boston.
Hmm?
I don't know if we made it to the 403 part on this.
No, we hadn't. We sort of got sidetracked,
I wanna
but.
make sure I'm not.
All right.
All right, so we all agree that the jury is going to need to delineate. We unanimously find this overt act exists as to each defendant, right? I mean, we're going to break each defendant's counts out separately, and
I think that
I agree, but think.
will, and to make certain that we present clearly to the juror, to the court, we do believe, yes, that the jurors have to make a unanimous decision as to each defendant and as to their overt acts, but as to whether the overt act it finds as to one unanimously has to, deal with the others.
I know, I mean, it can be wholly entirely separate as to each defendant. It needs to be a separate determination as to each defendant.
Yeah.
But for each individual defendant, does the state agree that the jury has to unanimously find 2 overt acts,
One.
one of which needs to,
One.
or happen within the statute of limitations.
We agree they have to at least find one
Okay.
that happened within the statute of
And
limitations.
it needs to be unanimous that, let's say they all find overt act 66, whatever that is.
I believe it's safest that they find
Okay,
unanimously.
okay. All right,
And
then I don't
we-
need law on that because we'll just do that the safe way, whether it needs to happen that way or not. Okay, so back to, so I still will need by Monday whether an overt act not listed can be the sole basis for the conviction. And now we will go back to to what we were talking about, which is this
The intrinsic.
allegedly intrinsic
Correct.
act.
So Mr. Ryan, given Mr. Blaylock is not here, but I will, since they were the two that were charged with the murder in one of the overt acts listed on the indictment, Your Honor, Mr. Ryan and Mr. Blaylock have entered a plea of not guilty to count one. And they are obviously charged with committing an act of violence against a person as alleged in the indictment in a manner that furthered the interests of the enterprise in the conspiracy. The three, I guess, points that Ms. Abbasi referenced in her brief were that the intrinsic or the act needed to arise out of the same transaction or series of transactions as the charged offenses necessary to complete the story of the crime, or is inextricably intertwined with the evidence regarding the uncharged offenses. And there is an or, so it does not have to be all three. So given that the jury will hear evidence of Mr. Ryan's and Mr. Blaylock's concerted efforts as they related to Mr. Holmes, they will hear evidence of Mr. Ryan's actions after the murder of Mr. Holmes. They'll hear evidence about their connections to YSL, but the fact that you have other members of YSL acting on behalf of Mr. Ryan to support him in a violent way against another person whom they allege only messed with Mr. Ryan's commissary, stabbing him just because he messed with Mr. Ryan's commissary, show the extent to which members of YSL go to assert their dominance, even in a situation like the Rice Street jail. And to protect one another, to show that you don't mess with one of our own. The argument obviously can be made by anyone. Yeah, this is not really what it's all about. But in terms of what the state is required to prove beyond a reasonable doubt to the jury, we alone bear that burden, given that it's evidence that there is violence committed on behalf of a member of YSL by members of YSL. We believe that it shows that the gang itself conducts itself in a particular way, and that the...
Okay, let's stop interrupting though. I mean, I assume she'll get to it at some point.
That the gang itself conducts itself in a particular way, and in Johnson versus State, a Supreme Court of Georgia case, whose site is 312 Georgia 481, decided September 21st, 2021, at Penn site 491. The court said that, of course, evidence is admissible as intrinsic when those three elements that we just mentioned exist. And they went on to expound and say, in applying this test, we have explained the evidence pertaining to the chain of events, explaining the context, motive, and setup of the crime is properly admitted. If it is linked in time and circumstances with the charged crime, the defendants, the YSL members are all together. They are the ones that are included in or that participated in the stabbing of Mr. Bussey, are all housed together at the Rice Street Jail. The time frame is shortly after they're put together in that situation, all together in the Rice Street Jail. In this particular case, in Johnson, it has a set of circumstances that are not exactly the same as this, but we believe are analogous in many ways. In Johnson, of course, the appellant was charged with participating in criminal street gang activity, and the state's theory was that he was involved in the gambling house shootings with Blood Gang affiliate Porter and several unidentified assailants in another restaurant shooting. The evidence related, as the court found, to the Boulevard Place shootings added significant weight to that theory because the evidence was linked in time and circumstances with the charged crimes, and one victim was a member of a violent gang. We are not alleging that it is on all fours with our particular case, but to the extent that the Johnson court found it pertinent to say that the intrinsic act, or the act that the state alleged was intrinsic, added significant weight to the state's theory for these reasons. We believe that that is analogous to our case as well, with 5 people, 7 total, acting in the same, overacting with an extreme amount of violence on behalf of one person whose connection, we believe, with the 5 YSL members is just they are all YSL members and they are acting protectively towards him. We have, we believe that that incident adds significant weight to our theory of the willingness of YSL members to participate in that enterprise in a manner involving violence to protect the dominance and the members of the enterprise and the gang itself. So the court found that even though the state didn't charge appellant in connection with the shooting, evidence of the incident was relevant to disputed issues in this case. So as Mr. Ryan has entered a plea of not guilty to count 1, conspiring to violate the Racketeer Influenced and Corrupt Organizations Act by participating in these acts or conspiring to participate in them, then evidence of the involvement of Mr. Blaylock, Mr. Ryan, Mr. Eppinger, Mr. McMullen, and Mr. Myrick, all of whom are also charged in this indictment with the conspiracy. Evidence of Eppinger being charged with the shooting of an officer, evidence that Ryan, who was promoting YSL while in prison when Eppinger got a bond for shooting at the police, that Blaylock is a co-defendant on the murder of Mr. Holmes, which is an overt act here, and that Demise McMullen is a
Good morning,
named
Anthony.
co-defendant on the 2015 murder in the same indictment, shows how intertwined these people, this type of action, and this gang itself is with one another. They're all inextricably intertwined with the evidence regarding the uncharged offense, which is the stabbing of Mr. Bussey. So we believe that it satisfies the requirement of the requirements of being an intrinsic act.
Okay, which of the three?
The third one, we believe is the strongest in that it's inextricably intertwined with the evidence regarding the uncharged offense.
No, it's the charge, it should read the charged offense. Right? I mean, it needs to be inextricable, right?
Yes, that the
Just a
case is
typo.
citing it wrong. Yes, thank you.
So-
And that being count one, the conspiracy.
So how is it? And you think it's also necessary to complete the story of the crime, right? You're not asserting that's the same series of transactions as the charged offense, are you?
When the court says the same series of transactions, we believe that it's an overt act, in as much as it could be considered an overt act to promote, to support the gang. So in as much as it is or can be considered an overt act for count one, and that it is gang activity, which it is.
All right,
And-
I'm not quite sure where I got this language, but I jotted down, and I think this is kind of the definition of inextricably, or an explanation of inextricably intertwined with the evidence regarding the charged offense,
Mhm.
is that it is an integral and natural part of a witness's accounts of the circumstances surrounding the offenses in the indictment. Anybody
So
know if that's
So this-
that's as to, that's the explanation for what it means to be inextricably intertwined.
I think that came from Murphy.
That's Williams versus State, 302 Florida 474. Cited in the brief.
What year is it was Williams?
2017, it's cited to 11th Circuit.
Okay, and I think that language is also in a Court of Appeals case in 2020.
Okay, so, but I mean, if that's what it means for it to be inextricably intertwined with the evidence regarding the charged offense, how is that an integral and natural part of a witness's accounts of the circumstances surrounding the indicted offense?
So if the indicted offense is the conspiracy itself, and our witnesses talk about what they've observed, and we have evidence of what has occurred to further that conspiracy.
So would this be a witness who's being regardless, or is this a witness as to, I mean, obviously, if they're just coming in to testify about what happened in the jail, that wouldn't be the same thing, because I would have already made the determination, oh yeah, you can talk about this. Is there going to be any witness who there's no way they can give their account of how it is that any of these defendants is guilty of RICO without telling the jury about the stabbing?
No, we're not saying that. We're not
Okay.
saying that at all.
So then it's
no.
not inextricably intertwined.
But it does, it's an uncharged offense. That arises out of the same transaction or series of transactions as the charged offense of count one. And the series of transactions is the acts of violence that have been described. One of the overt acts, as I said, is the murder of Mr. Holmes by Mr. Blaylock and Mr. Ryan, as we've alleged in the indictment.
And then how does
And
this
then-
arise out of that transaction?
The series of transactions, one of them is that the series of transaction is the set of actions that occur after, before, during, and after that murder itself. The series of transactions are the overt acts that help promote the purposes of the conspiracy. You have Woody Lee posting, I'm sorry, we made you a thug, so early little thug. You have people who are acting within YSL in support of Mr. Ryan. Mr. Ryan essentially talking about staying true to YSL regardless of his circumstances after the murder.
All right, and are all of those overt acts?
Yes, those that I
are
just
alleged?
named are, yes, alleged overt acts. So the series of transactions, we would argue, is not a simple matter as on Monday, July 3rd, he got up, went to the store, bought a gun,
Yeah.
did that. It's
All right,
more
remind me
broad.
when the jail stabbing occurred.
It was February the, what day? February 20.
Of,
February the 1st. January the 1st of 31st of 2023.
January 31st, 2023,
Yes.
and he'd been in prison, I guess, since 2019. When did they all get moved to the jail?
Mr. Ryan, I think, and Mr. Blade, those 5 co-defendants were, I'd have to look and see in Odyssey when they were transported, put together in.
Roughly.
Thank
Okay,
you.
Approximately.
okay, that's, I mean, approximate is fine.
And also, Your Honor, under 104, and I get that we are still hashing out whether or not it's intrinsic. Once the court makes that determination, and we believe that it's clearly intrinsic regarding the conspiracy and the gang itself, there's another argument in support of its admission and use at trial that we make under one of the other rules of evidence, but not until we finish this part.
Well, I'm curious now as to what that would be.
Just that under rule. And I'm also curious about how the court will see or not see this position that I'm offering. But under 24-1-104, which specifically deals with the court handling the admissibility of evidence and the court's determination of it. 24-1-104E expressly says that this code section shall not limit the right of a party to introduce before the jury evidence relevant to weight or credibility. And so to the extent that part of our evidence, and it doesn't, speak to the weight of the evidence of the murder, but we believe that it substantiates and it corroborates our assertion via the overt acts that we have listed, that there is this conspiracy and that there are efforts that are continually made by members of YSL to support and protect one another and to advance the dominance and notoriety of the gang through acts of violence and assault.
All right, well, I do not think 104 has any bearing whatsoever on whether y'all can admit it before the jury.
So, okay, see, I knew.
Okay, so that takes care of that one.
all right.
All right, do you have any, can you look, if you haven't yet, for any case law that deals with kind of a similar set of facts? Mr. Atkins is shaking his head, yes.
Since
that
he
can
is-
look for that.
Oh, that is, we definitely can. I was just trying to make sure that I fully got what the court was saying. So in saying the same set of facts, is the court speaking that
Similar set of
specific
facts.
as to, you know, somebody jumping somebody?
Well, I mean, yeah, ideally, if you could get that, that would be great. But no, it doesn't have to be that specific, but something that deals with gangs and or RICO, because what I hear you saying, or what I think I understand you to be saying, is that part of why this is intrinsic is because it's necessary to give a full story of how YSL is this ongoing criminal enterprise that uses violence to protect their members.
Right.
Am I understanding you correctly?
You are, and to assert its dominance. And in support of that, I also say that each of the members of YSL, Blaylock, Eppinger, McMullen, Ryan, and Fleetwood, had all, I believe all of them had been brought in from prison for YSL related offenses that they had been convicted of. Eppinger had been sentenced to prison off of a probation revocation for an armed robbery after he shot Officer Rogers. That was a YSL related incident. Mr. Fleetwood had been brought in from prison after shooting at Milton Howard, who at the time was driving YFN Lucci's vehicle with tinted windows. So the argument obviously could be made. He didn't know it was Mr. Howard. He knew it was an ops car. So all these people are all incarcerated because of YSL related offenses. And then you put them all in the same little area and they are once more acting as one single bullet against somebody they believe is a threat. But I can and we will look for a case on all fours with this particular set of circumstances.
Okay.
Your Honor, should we say about 403 argument until the state?
I mean, I honestly think the 403 argument is easier than whether this is intrinsic. But yeah, I'll go ahead and hear that because maybe that'll be dispositive of this issue.
So would Ms. Abbasi, should I let her go first? Sit down and see the floor. Does the court want to hear from the state?
It's in the brief, so I'll let you begin.
Well, I mean,
They have the burden. I'll give you the.
all you really say in the brief is it doesn't meet 403. You don't really say why.
Well, it's that it has to survive the balancing.
Okay, well, that's pretty clear.
To exclude what is a scant or cumulative urban force, I think everything in here we're dealing with is scant and cumulative. There are, I don't want to get wrong, how many other acts in here the state can prove. These are not necessary. I'm sorry. Is that on? That in the 403 analysis, the court should determine the prosecutorial need, degree of similarity, and temporal remoteness. There are 191 overt acts. I think by the time the jury has heard all of those, they will have heard quite a bit of evidence regarding how gangs operate, examples of criminal street gang activity, already quite a bit. I'm sure by November there will be more. Don't think there's any prosecutorial need to be coming up with these things additionally. There is plenty. Your Honor is able to exclude evidence which is cumulative, which is of course prejudicial, and a waste of time. I think that's where we're getting to in this circumstance. Clearly, there was enough evidence for the grand jury to return an indictment when
Well,
they heard this.
that's a lot lower standard.
It is, but if even that lower standard, it was met there, then I don't see how it suddenly become necessary here.
Okay.
Oh.
Go ahead.
Judge, I've heard, and everyone I believe has heard a lot about the notion of the evidence being cumulative, as if there is a certain amount of evidence, the state who bears this very high burden, I'm sure we'll hear told over and over again in closing arguments, that the state should be allowed to present to meet that very high burden. And I don't believe that cumulative evidence means proof of a different kind to show or to prove the same act. Just because the state has 150 ways to prove that the defendants conspired to violate the Georgia RICO statute, and the state, in an effort to ensure that each of its victims are represented and that the jury hears sufficient evidence to allow it to convict each of the defendants, doesn't mean that the state should be constrained to putting up one piece of evidence, one picture showing somebody throwing up a gang sign.
Can I ask you a question? How many of your overt acts, if any, are assaults or aggravated assaults that are designed to either protect alleged members of YSL or promote or continue the, I can't remember the word you said, but the dominance, assert the dominance of YSL?
As it relates to Mr. Ryan, or just in general?
In general, since the argument is this is done to protect members of YSL and
To assert their dominance.
assert the dominance of YSL.
Okay. Since an overt act does not have to be a crime, I'll just name them, of course. So number 9, where defendant Williams asserts in one of his songs, YSL.
No, that is not what I mean. I don't mean saying you're going to do something. I mean actual assaults on people.
We have Mr. Holmes's death is alleged by the state to have been a murder of someone that they believe to have been a member of a rival gang.
All right, so
Mr.
I'm sorry. I mean, I guess maybe, so because it's a rival gang, that would be dominance.
Yes.
And
it's-
that's overt act, what, 79 or 69?
And I can also even be more precise there as I look for that number 79 or 69. Mr. Drinks's murder is alleged to have been a direct retaliation for the death of 2 people who were
Okay.
associates.
Your Honor,
Mhm.
I'm sorry, I'm just trying to
69.
I'm trying
determine
to
what you're
figure-
asking. Are you asking what the indictment alleges?
What,
Is-
yeah, overt acts.
Well, the
alleged in
indictment,
the
as I
indictment.
understand it, just broadly alleges that the overt acts are done to that, for those purposes. The indictment broadly alleges several purposes and doesn't delineate which overt acts are designed to do what. So the answer, as far as I understand your question, would be all of them. They've
All right,
alleged
well,
all of them.
But
I mean, I'm asking the state sort of what, I appreciate that position, but I think I mean it a little bit differently than that. And yeah, sure, they could end up saying every one of these does all of these things, but I'm kind of asking them to be focused on aggravated assaults, obviously, or worse, murder, that are for these very specific purposes.
So to answer your question about the number for that murder, it was overt act number 79.
All right.
Also, the act on 4/28 by Mr. McMullen.
Overt act number
April
28.
April
Oh,
28th.
okay, yeah.
I'm looking at them in chronological order.
All right, that's fine.
The act by Mr. Garlington, Mr. Sledge, that act of shooting Miss.
Are we talking about things like rival gang type incidents?
My understanding of what the court said
I
is
just
what
want to know what
acts
the state's position is.
that were done to acts of violence done to promote either the notoriety or to protect
the members of YSL or to promote the dominance of YSL.
So the shooting, we believe, by Mr. Winfrey of Lil Wayne's tour bus, which would have been a different one. It's encapsulated in 39 and 40. The shooting of Mr. Murphy. On April the 12th.
Do you have any other
Montgomery.
overt acts where members or alleged members of YSL are basically doing a beat down of anybody because somebody from YSL got threatened or attacked?
We have other ones where they're shooting at other members, and we
Okay.
have where they, for instance, Mr. Kendrick and Mr. Arnold go out and plan to shoot somebody because someone jumped on Mr. Arnold in a club.
And that's an overt act?
It is.
Okay.
Where also I think we have. Yeah. And they are, I think, Acts 41 through 45 is the
Okay.
This is the murder
All right.
on the 28th that or the aggravated
you.
assault that I talked about.
Okay. All right, well, y'all see if you can find me some more on point factually case law, please.
Okay.
And
Is the
I know
court,
y'all want a decision, but
that's the,
we're gonna come back to it yet again.
and Your Honor, in terms of the number of acts that we've enumerated in here, does the court want specifics or just the number?
No, that's all right. I mean, you've told me enough. That's fine.
Okay.
I mean, it's not like that's critical to my determination.
Okay.
I just was wondering if there were so many that this was something that would really be cumulative, but it doesn't sound like you really have anything that similar to this.
And as well, Judge, in terms of judging whether or not something is substantially more prejudicial than probative, it would have to, I think I've said it before, it would need to tend to sway the jury to convict the defendants on a ground different than something that has been alleged in the indictment. And given the allegations that we've made, we don't believe that this comes near that category of cases or circumstances. As well, Judge, I know the court is aware, but just to put it out there, 403 is, all of these rules of evidence are rules that favor admission. And so 403 is not to be used as been alleged to limit the state's ability to present evidence so much as it is a permissive statute that under very rare circumstances should be used to exclude relevant evidence. And the mere fact that a defendant may feel that, oh, the state has too much evidence against me is not one of those circumstances that the courts have recognized.
So actually do speak about prosecutorial need.
To the extent that the argument throughout is that YSL is a gang, that everything that has been, that YSL is a music label, that everything anybody does is just their own independent act that has nothing to do with YSL. from day one, from openings throughout up to even now, the assertion by every defendant is, and even the witnesses, I did it for myself, by myself. Every step of the way, the state is having to rebut that assertion that this is just me. I'm a criminal, but they aren't.
Okay.
So to the extent that there's no one here willing to stipulate that crimes are being committed by them and others with whom they've conspired to promote or on behalf of YSL, the state has a very strong need to present evidence of one, concerted efforts to commit the acts that we've alleged, to show the conspiracy between the defendants, and to show the purpose behind their concerted efforts.
All right, thank you.
Your Honor, I'm just looking
ma'am.
here at some case law on prosecutorial need to see what I have to answer Your Honor's question in that respect. It's in 403 itself, in case law, kind of more specific to that. I'm going to keep looking. I'm looking as I'm speaking here. As far as the prosecutorial need, I'm looking at cases where the need is there's no other source for that information, or at least limited sources of that information. I'm not sure how many hours of gang expert testimony the jury has already heard from about how a crime can further a gang or be part of a gang. I think the need to that point on this principle, that there is no need. They've heard about it in depth. They will continue to hear about it. And as I said, I'm trying to look and see if I can get any more case law to specify if we have a level or a test for what need is.
All right, thank you. Well, if you find something else, feel free to just, shoot it over in an email that you share with everybody. That'll be fine. It doesn't need to, I mean, if you want to file it as a brief, that's also fine, but.
What I've got, just looking at some case notes here. Prosecutorial need to induce a prior rape-related incident to show. Yes, I'm sorry. Explaining that the prosecutorial need to introduce a prior rape-related incident to show the defendant's intent was high because there was little other evidence supporting the charge of aggravated assault with intent to rape. That is a case, Kirby versus State, 304 Georgia at 483. And I haven't read that case. I'm looking at it. It is cited within Jackson versus State, 306 Georgia, 69 from 2019.
All right.
And Your Honor, could we get clarification? Is that a 404B case or a 414 case or 413 case, Kirby?
This is addressing a 403 issue.
Is it in the context of a 404B?
I don't know, but it's not a different analysis under 403.
As I said, I've not read the full case.
Yeah, I mean, it's fine. I understand the concept. Okay, let's set that aside and move on to something else. So there was I've got some notes of things we were going to circle back to. And one of them was a video of somebody smoking pot wearing a chain and it saying some things. BB maybe and Eppinger, some about robbing Smith. What was that about?
Yes, Your Honor, I believe that, Mr. Shard, we were supposed to narrow
It
down
was-
what
yeah.
videos the state we were going
Okay.
to admit. I sent that over, a few weeks ago, which ones we intended to use. I'm not sure we've been able just to talk about it in light of the last couple of weeks.
Okay, well, these are notes from back when we had that non-jury week, which I feel like has been a while ago now.
Yes, it was the week of August 19th, Your Honor.
Yeah, that's what I thought. So and that, I guess that was with regard to counts 27 through 29, maybe, is, I think, what I wrote down.
Yes, Your Honor.
So is that a video y'all intend to utilize?
We sent over, there are portions of that video we intended to utilize. I believe that the portion that was at issue is not a portion that we need to publish to the jury, Your Honor.
You're not going to show the jury?
Portions of the video. So the video is maybe approximately 5 to 7 minutes, and there's a portion, and I want to pull up my notes to see what I actually sent over to defense counsel as to what timestamps we intend to use, but a portion of it is relevant because it shows Mr. Eppinger and Mr. BB, the two
Mhm.
people alleged to have committed this armed robbery,
Right.
on the phone. And a portion of that video, Mr. Eppinger appears in I think it's like a Instagram picture, an Instagram video, and BB shows him the chain. But there's another portion of the video in which Mr. BB is pointing a weapon at the camera. So there's just relevant portions, and we just haven't had the opportunity to discuss it, Your Honor. And I can let defense counsel know what date I sent over what the state intends to show.
All right. Does defense counsel still object to whatever portions those were?
Yes, I'll re-forward the email. August 23rd at about 1:55 p.m.
Question.
sent are approximately 5 clips that probably total together about 6 minutes of actual viewing. Is that about right, Ms. Hiller?
Yes, sir.
Okay, so, in all honesty, we haven't had a group this is all acts involving someone that's not sitting here. And if we could have a couple minutes
Okay.
just to talk as a group to figure out
You may.
what our stance is. on
All right,
this.
and you know what? I may have y'all do that over the lunch hour. So the next thing I had us circling back on was, and I guess maybe these were from I don't know, we were going through maybe one of the sets of statements, because I've got like page 523, 513. Oh, these were the wiretaps, maybe. Big Nick.
Yeah.
Waters Road. And then, oh, the comment about, yeah, this was the wiretap stuff, the flipping the car and laughing about that. And the state had said y'all were gonna narrow what you wanted to use from that and let us know. Do you recall that?
Just trying to remember flipping the car portion.
I don't know. It was, there were 2 reference numbers. One of them was 513, one of them was 523. It was on that chart that you gave us, I think. On the second page of it, Garlington talking about how they came through and thought they were going to come back and they were going to get ready to light them up, laughing about Shamel Drink's murder and the need to re-up on drugs to sell. And I had determined that the drug part was in, but y'all were gonna look again at that other part. You said there was a non-hearsay purpose for it. Did did y'all ever go back and do that?
By lunch, we can.
Okay.
We'll be able to have an answer by lunchtime.
Yes.
Would you kindly just repeat the 2 reference numbers?
Yes, 513 or 523. On the chart, it's 513.
Thank you.
And then when we got to 1109 or 1124, there was an argument that that shouldn't come in against Nichols or Stillwell because they had already been arrested at the time and somebody was going to provide law on that.
Did that fall under the broader proposition that the court sort of touched on earlier regarding whether or not overt acts occurring after arrest could be used to prove the conspiracy itself, which would include people who have been arrested prior to the act being committed? If it did, you'd like to sort of address it?
I mean, I think y'all would need to establish that they're still a part of the ongoing conspiracy. listened to and did re-listen to the part that on the chart is 1974, and I think the other reference was 1999. And this was, I don't know if the argument was 403 there. Confusion, I think, was the argument. And upon re-listening, I don't find that to be a 403 issue, so that is admissible. That was about as far as we had gotten. And then, of course, we still need to circle back on the that one that we got bogged down with the nested hearsay with Garlington talking to Tounk, who talked to Quay, who talked to Rel. So why don't we break for lunch? Y'all got some tasks to do over the lunch break. Do you have the material for me to look at? Yeah, it's not noon yet. It's about 1:45 but.
I just reached out to our other team members.
Okay.
To try and.
All right. Are you gonna email it or bring it as a hard copy or what's?
I'll email it. That makes it quicker.
Okay. All right. Please do that over the lunch break. Let's reconvene at 1:15.
Yes, Sharon, and I also put 460 on top of it.
My copy of 460. We never did find.
I found our copy.
Okay, great. Thank you. Thanks.
So what I'll do is for someone else channel, we can watch until they return from lunch. Where's AP? Maybe you must be off today. This looks work. Not Williams. All right. Here's Cat.
I think that applies to love. I think that might be why you're thinking of it. Shout out for the throwback song there. Thanks for the 5. JT says, when in doubt, over talk it out. No. I can't believe it works on this judge. The defense can't do the same thing. Shout out to JT for calling it what it is. Leah's dad says, love is presenting this whole thing in a way that criminalizes Black men for having friends. I'm sure friendship is a foreign concept to her, but Jesus. Yeah. Yeah. And not even that. I think, the whole idea of getting jumped in prison, you might not be friends, but you look out for people so that way people also look out for you. It's almost a reciprocity thing just as much as it might be a friendship. Doesn't mean that there's a gang affiliation or someone doing something to in furtherance of YSL. It could just be to form bonds and show reciprocity for the alliances we formed while we're in here to help protect each other and make sure people aren't trying to take our commissary money. So you're right. You are right, Leah's dad. Always good to see you. Kristen Vasquez says, being down with friends doesn't mean you're in a gang. Common sense seems like it doesn't exist on two sides of this courtroom, like the front and the left. G. Lander says, love, speak it into existence, manifestation. That's a great way to put it. Board in her bedroom has the phrase, YSL is a gang, written 50 times on it. Or the Bart Simpson chalkboard over and over. YSL is a gang, YSL is a gang. Oh, you want to plea out? Yeah, I need you to go to this chalkboard and write it 50 times. YSL is a gang. But G. Lander, that is a great way to put it. Speak it into existence, manifestation. Casey Doc, thanks for the 5. Miss Love, Your Honor, if you let me speak long enough, I'll eventually catch your alley-oop. Your alley-oop, yeah. I mean, to be fair, Love did say she was going to argue all the reasons. And then she didn't argue all the reasons. And then Whitaker came in with the assist and kept insisting, I think you'd have a better chance with the 403 argument over intrinsic acts or whatever. She mentioned that a few times. And Love didn't really catch the assist, but okay. It's okay. She's got until Monday to write it. Shout out for 0 more chances. Thank you, Casey Dog. And then another one snuck in here as Satchel gifted another membership. I got to update my banner. We are at, how many new members? Holy moly, we have 57 new members. We're going to get indicted soon, you guys. All right, wait. So 57. Holy moly, that's a lot of members. Thank you so much for sneaking another one in there. And again, guys, if you got a gifted membership, say thank you. I know it's hard sometimes to see who actually gifted it to you if you're not looking at the screen, but someone will know that you appreciate it. Bittersweet says, I changed my mind. She's always liar love. Yeah, I think she earned that title. She definitely earned that title. Leah's dad says, maybe it's because my daughter's name is also Leah, but I'm getting real life mad love keeps cutting her off. Yeah, Leah Abbasi. And then she called it out. And the judge called it out when Leah was speaking, and it seemed like Leah said something while Love was talking. like just imbalanced. But let my not daughter finish the sentence. That's right. I think a lot of us are Team Leah being able to finish her argument here in this chat. We are with you. As Satchel says, is Doug an honorary member of the Rico Brady gang? Oh, I don't know. Is his name green? I can imagine maybe he hasn't turned on the gift settings. So we can't force him. We can't sneak him in. Because remember, guys, you have to have the setting turned on. You can click the little money symbol in the chat to enable the setting that allows you to receive a gifted membership. So if Doug hasn't received, if he hasn't done that setting, we can't force him to join the gang. So shout out to Doug Weinstein. Great question. Army Nurse says, to bring a RICO charge, don't they first have to prove that YSL is a gang? So far, all I hear is theories, but not significant proof. Well, the tricky part is in bringing all these charges, the additional counts outside of the, count one, they're trying to prove it all at the same time. So there isn't a precursor step. It's simultaneously. It's at the same time. So they don't actually need to prove that YSL is a gang first before they can start proving that things happen in furtherance of the gang. That's why everything is so broad, because we're trying to prove both things at the same time. That this stuff was done in furtherance of a gang, and therefore, because these things are being done in furtherance of a gang, it's also proving that there's a enterprise, an organization formed for the purpose of, some type of criminal activity. So that's why it's so broad and all-encompassing, especially in the state of Georgia, where they don't need to prove an element of pecuniary interest. So that's the super giant loophole. Great food for thought there, Army Nurse. Thank you so much. 403 says, according to Love, Daniel Gang needs a RICO too. Daniel Gang? Daniel Gang. I'm missing on the Daniel Gang, unless it was a typo and maybe you need a K&W Gang. I don't know. Sorry, 403. David says, we need to do an MST. Wait, hold on. I gotta Google that. What does that mean? Oh, Mystery Science Theater? Is that what that means? Okay, so Mystery Science Theater, lower bar, but with Fry, Bender, and Leela lampooning Love and how much she talks. We might need a snoo appearance too for that one. Thank you, David. Dante says, every time YouTube buffers, YouTube is tired of hearing Love talk. Me too. Nine Wolf says, if you mess with anyone's commissary in jail, the same results could happen. It's unfortunately a very normal outcome, excluding, it has nothing to do with YSL specifically. Like, did YSL get word that this was happening before they had a chance to react and said, oh, we just heard that 2 minutes ago you found out someone was conspiring, so just go take action right now. Things don't move that quickly with out of custody communications. Whatever happened seems like it would have happened and been decided in the confines of the jail or prison. Where's Ryan being held? Wherever he's being held. Like, the chances of it involving a, hey, you're the leader, what should I do now? It just seems unreasonable, seems really unlikely. Thank you for the $4.99. Mom Two Boys Knits. Be careful with those hand symbols that you might be making while you're knitting. So glad to be here. Thank you so much for being here. La Mustache White Gang says the biggest crime is anyone as repulsive and unlikable as is Capo of the Georgia's people-funded crime syndicate gang being surnamed Love. That's a crime. Yeah, and it's a... I tried to send some love to Nick Starro yesterday, and I had to specify that I mean lowercase, because I don't even want to... Now I feel like when I say the word love, you guys are watching this trial, I'm talking about this trial a lot, my brain is now the neurons are going to fire and think of Adrian Love and not the regular word love. So I was like, man, I can't even say the word love anymore. You are spot on, Mustache Wipe Gang. And dropping Nick's link in the chat, you guys know the drill. If you don't already subscribe, tons more content over there to binge. Super huge friend of the channel. I would call him a friend personally, even though we've never met. Love, love, love Nick Starro. As Satchel says, I've noticed that Love is not aware that her mic is picking up the attorney work product the entire time. She's so interested in speaking that she doesn't switch it off. Yeah, it's like her. I'm not going to say I have not heard her through the microphone, but it's just her. And it's when she's leaning in to say what, she wants Hilton to say, or she wants to be heard by the judge. So it's only her. It's not picking up other things. And if it was really a problem and Hilton was aware of it for several days, Hilton should have brought it to the court's attention several days ago. So all of that just seems like a whole excuse. Thank you for the 10. Chloe says, I'm in Lower Manhattan. I do not envy you. So I'm in and out. Is she still loving herself? We're finally on a break. I'm sure it's not the end of it for today, though. And I know I do not envy you for being in Lower Manhattan, dealing with, the courts and everything down there, the traffic and everything down there. So best wishes to you. Ever since I moved to Florida in an area that's not as congested, I'm like, I don't know if I could live in a city again, a big city at least. Shout out to Chloe. Penny G says, please pass me some word salad. All right, guys, we got to pick dressing. The Mustache Wipe Gang says, I've been served so many tasteless empty word salads by ADA Love. I'm beyond negative calories, empty calories vegan. I wish Judge Whitaker judged like a judge. She could have stopped and moved this on. And then I thought it was interesting when she said, all right, let's move on to, she took a lunch break, but it seems like we're going to be talking about the nested hearsay when we get back. And what was the word she used? Bungled? The bungled argument or the bungled issue. She used some weird word. And it was almost like she was apprehensive to have to deal with this issue and disposition it. But I'm sure Bruce Harvey is going to make a coherent, narrow argument. He's not going to go into fluff world or filibustering land to try to make an argument. Bruce Harvey's going to make an argument that's supported by statutes or case law, or both. He's going to be pointed with it. So why are we apprehensive about taking up this issue when we just spent an hour and a half dealing with something that should have been resolved 2 weeks ago? So yeah, lots of empty calorie word salad today. Penny G says, judge when it comes, defense gives one chance rules. I'm sure we'll see it. Now that the defense will be leading with some of the other additional arguments, I'm sure we're going to see a lot more shutdowns and keep it moving. All right, we're wasting time. We can take like fake bets on it. Take some fake bets or guesses. Thank you, Penny G. Apunanwu says, Fulton County, you okay? Also, just because we aren't the jury, we can see and hear you. And I liked Thugger Daly had said, and it's another great thought. And actually, I see another update we're going to get to as well. We'll do that before we watch Day 114 with Leah Abbasi. But Thugger Daly, in response to this, the IT has informed Judge Whitaker that no private conversations are being picked up by the media stream. Thugger Daly responds, the state is just mad that the stream clearly showed that Sledge never wiped his nose at the jury, as Love tried to insinuate for some reason. So there you go. Great reminder that the jury can see, we can hear, they can hear. And you can't just make stuff up. Elizabeth Wright says, I'm new here and love your content. I do have one question that you may have covered, but could the Georgia Attorney General take this case and dismiss it to keep from wasting taxpayers' money? I'm not actually sure about a process there. To me, typically attorney generals handle things where the state would be named as a party. So a lot of times like things like election fraud or a public official doing something, that's kind of where the attorney general steps in as like the attorney for the individuals tied into whatever's making the state the party to something. So I'm not really sure exactly the nuances of how this would play out. I am so glad you're here though. But reminder to everyone, I am not an attorney. I like to try to look and research things and learn, and doing YouTube was kind of an accident, but it's awesome to be here now with you guys, with the honorable chat. So glad you're here, Elizabeth. Thank you for the 10. Future Miss Martin 2.0, gifting 5. Thank you so much. I'm going to add you to the banner. You guys always know the drill. Shout out to future Miss Martin 2.0. You can type FMM. Way easier to type. Now, future Miss Martin occasionally, and I never know your own channel. So unfortunately, the stray capture here is going to be hella excited utterance. But future Miss Martin guests occasionally as a panelist with excited utterance on a program called Hearsay for Days, which is every Sunday. And Hearsay for Days is where, when it comes to different legal cases, different legal topics, hella excited utterance and her panelists of guests, which include potentially criminal, that's Sean Martin, future Miss Martin, they're engaged, and then Dolly. So Dolly talks. You hear me talk about Dolly a lot on this channel, and you guys hang out with him in the chat often. Usually some combination of them will do a panel stream on Sundays on Excited Utterance's channel. It's super awesome. They talk about several different cases. It's a nice potpourri of things. So if you want to catch future Miss Martin and the panel, this is Excited Utterance. And I would love to see some of you guys over in the chat. I love hanging out in the chat over there. So good to see you. And thank you so much again for the 5 gifts. Now, as Satchel says, suggestion, the jury form needs to be on a laptop, a spreadsheet showing a grid of defendant and charge status. Yeah, I think that's going to be tricky in and of itself. Like, how do you keep the who versus the what? And then these jury instructions, some of the counts are going to involve names of severed co-defendants, because some of them, it's being alleged that, like Christian Eppinger, I think, is in some of the same counts named at the same time as Shannon Stillwell. So the jury's got to go through all these things, and it's going to be confusing because the jury needs to understand that all these things we've heard about Christian Eppinger and maybe Demikian Garlington, we didn't get to see them testify, but we heard their names so many times. We've listened to their wiretaps. We've seen evidence that really seems more about them than the 6 overall sitting here in the courtroom with us. But when we go through these counts, when they're named, we can't, if I, for example, think Shannon Stillwell didn't participate in something, but the count involves somebody else's name, and I think that person may have been participating in the thing, well, do I check yes because I think this incident happened in some part? Or do I check no because I think that these 6 co-defendants are not guilty beyond a reasonable doubt of that specific count? And each of these little nuances has to be instructed to the jury. But jury instructions are complicated even in normal cases. You have a 3, 4, 5-day trial, and you're watching the verdict, and suddenly, oh, there's a note. The jurors have a note. They don't understand what this thing means. Can they be read the jury instructions again? Well, just imagine that at scale with 6 co-defendants, a bunch of severed co-defendants, over 100 different counts, and a very complicated case with days and days and days and days, months and months and months of evidence. It's going to be a mess. It's going to be a mess. So I have no idea how they're going to even approach jury instructions. I would not want that task. Great food for thought. Colleen became a member. Thank you so much. Positive Q says, I guess I'm YSL because if I'm with my girls and I get jumped, they better help me. Yep, there you go. This is such a waste of time, and the judge keeps helping her over and over and over. She Loves Fantasy says, someone in chat said judge is scared of Fani. Nope, it's code. Accusing one is an assault on all. Tone against defense is about Glanville and the court. Yeah, I think a lot of it is that protection of the court. And I do think that the state obviously is closer in branch to the citizens, the defendants, and the counsel that represent them. But there has been some clear, explicit, we're not going to talk about Judge Glanville. We're not going to talk about the former judge. She didn't even want to touch a jury instruction. She had to give a jury instruction to, disregard, don't think into why there's a different judge sitting here today. She had to do it. But if she had discretion, I think she wouldn't even have mentioned it to the jury at all. So definitely huge veils of protection up there to protect the entire court system itself. Thank you so much for the 5. Always good to see you. MT says, Kat, when we get locked up for RICO, if someone takes your tray, I'll make you a good shank. See, look, this is friends looking out for friends. This is not in furtherance of a gang. Appreciate you, MC, holding it down. As Satchel says, the honorable chat. Thank you for the accolade. Put it on your resume, guys. You are members of the honorable chat. Thank you so much. Now, what I said I wanted to show, I had just seen an update here. Shout out to Thugger Daily. And I'm linking to this post right now. Now, Thugger Daily says, update to Brian Steele Supreme Court appeal of Glanville putting him in jail / contempt. The state has filed a brief saying they do not consider themselves an important party in this appeal and does not intend to file anything substantive because the matter of contempt is a collateral issue that doesn't have a bearing on the main case. In other words, Glanville's representation is the only one that needs to respond, in their view. However, there are parts of Steele's position that go into facts directly related to the case, such as, was the ex parte proper? Was there misconduct by the state? Did defense have a right to be there? The state's position is that this appeal can be handled by the Supreme Court without commenting or answering those questions, and asks that the court refrain from doing so they do not affect the actual case. Now, we can read this real quick here. Looks like this is the full thing. Let's see. Yeah, okay, cool. So basically, instead of Brian Steele filing this appeal against Judge Glanville and whoever's representing him, and then the state of Georgia's like, keep us out of it. So we'll breeze through this. We'll do it as images. Zoom in. So appellant Brian Steele appeals from an order of criminal contempt issued by the Chief Judge of the Superior Court of Fulton County. Although it is criminal in nature, this is not an appeal from a criminal conviction in which the state of Georgia acted as prosecutor. The state of Georgia announces that it does not view itself as a party in interest to the current appeal, and for that reason, does not intend to file a substantive response to the brief appellant. In a letter to the parties, notifying them about potential conflicts of interest, presiding Judge Peterson wrote, "This appeal is not an appeal from the underlying case, but of a collateral matter between the trial judge and a defense lawyer in which the district attorney's office has little cognizable interest, at least as I understand matters at present." And this was July 11th, 2024. The state agrees with the presiding justice's initial assessment that it lacks a cognizable interest, that's going to be C for cognizable, interest in this appeal. As such, the state does not assert a position in support of or in opposition to the merits of this appeal. The undersigned feels compelled to note that the brief appellant, sorry if this is tiny, I guess I can make it a little bigger. Move my picture up to the top. The undersigned feels compelled to note that the brief of appellant and the amicus brief both include assertions or comments regarding the underlying case, which the state does not believe are necessary for resolution of this collateral matter. They are instead specifically germane to the underlying case. This includes, but is not limited to, and this is blurry, so you might have to rely on me reading it to you. Lawfulness of the June 10th, 2024 meeting in chambers, with a footnote. 3 Superior Court judges, here we go. 3 Superior Court judges have ruled that such meeting was lawful. The original trial judge, that's Glanville, and the successor trial judge. So we had Krause and now Whitaker. Or likely lawful, the recusal judge. So they're citing the record here, noting that this court agrees generally with the chief judge's assessment of the propriety of the ex parte hearing. So whether that meeting in chambers was a critical stage at which the defendant had a right to be present, we've got a footnote here. 2 says, on information and belief, the successor trial judge has ruled the meeting in chambers was not such a critical stage. And then 3, so appellant's gloss on specifically what occurred at that meeting, whether participants in the trial engaged in misconduct. So that footnote says, the state maintains appellant's assertions of misconduct on the part of the chief judge and the prosecution are incorrect. So the state's making an argument here, but saying they don't have a germane argument to make, but okay. and the basis for the chief judge's recusal. And that footnote, we've got another footnote. The recusal judge determined recusal was necessary based specifically on the chief judge's description of past events in making a record on the issue of recusal, which description occurred on July 1st, 2024. So this is the day that Judge Glanville made the judicial record, where he read into the court basically his findings. And that's the day that he noted, and I didn't look for it, but my deputy brought it to my attention. They saw a video of Ms. Bumpus in the hallway speaking to defense counsel. That's the day they're referring to here, that judicial record. Such matters are specifically germane to the underlying case rather than to this collateral matter, and information related to them is not adequately or fully included in the understandably limited record on appeal for this collateral matter. The state cautions against any language within this honorable court's ultimate decision of this appeal, which the defendants in the ongoing criminal trial below might interpret as being binding on that criminal case itself through the law of the case doctrine. Well, sorry, it sounds like the state is trying to be both a friend of the court. They're treating this almost like an amicus brief, while they're also saying they don't have skin in this game. So, like, which one is it? It seems like you are responding to the thing that you're saying you're not related to, but okay. The undersigned conveyed to counsel for Mr. Steele on August 2nd, 2024, the state's position that it is not a party in interest to the current matter and does not intend to respond substantively. If this honorable court would like the state to take a position on any portion of this appeal, the undersigned will do as directed. Additionally, this appeal is scheduled for oral arguments on October 22nd, 2024. Should this honorable court prefer a representative from the state to be present for those arguments, despite not being a party in interest, the undersigned will make himself available for that purpose. Barring either development, the state simply wanted to provide this honorable court with this information and to make explicit its decision not to file a substantive response. This filing respectfully submitted on the 10th day of September, and it's Kevin Armstrong filing it. So there we go. There we go. This is the link to read this and or follow Thugger Daily if you have not done that yet on X. Totally worth it. You will not regret it. But what do you guys think about that? What do you guys think about that? And guys, if you're like glad that it was short, that there was some brevity, it's because there's a character limit for these filings. Oh, shout out to Thugger Daily. It's okay. As soon as I started reading the document, I started fumbling with cognizable. And substantive used to beat me up too, because I used to say the UK pronunciation, which is substantive. And people were like, no, that's not how it's pronounced. It is in the UK. But I'll switch to the American, the substantive. And let's see. No, I don't believe, I just checked on the ruling for, the Riley v. State over the oral arguments that Steele delivered in front of the Georgia Supreme Court. No decision. I didn't even see it listed as a upcoming ruling, so I think we're still a bit of a ways out for that. I don't know why they told him orally in court that day that they thought they'd have a response for him in about a week's time, but whatever. We'll see it when we see it. I'm sure it's coming. It's not just going to disappear. But yeah. And then they said court would be back at 1:15. We have just shy of an hour. Let's see. Let me pull up the day 114. That's about an hour. And I'm going to use it. I'm going to use it as a way to double up and heat up my lunch, eat my lunch. So I will be here. The me on screen will be the old me from the day this was recorded. There's a link if you want to bookmark it on your own. We're going to look at Leah Abbasi's argument on day 114. Many, many moons ago. Many, many moons ago. Not many moons, but like a moon ago. And there's already captions built into the screen. We'll do 1.25. And for anyone that joined late, good for you. You missed an hour of Love trying to argue this orally because she never gave a written response when she was supposed to. And the judge very graciously gave her until Monday to respond. So that's where we are. Larry, thank you, by the way, for the super sticker, Larry. And Chloe, how the heck weren't you a member already? Thanks for becoming a member. And then Ike says, always be aware of statements about not making statements, referring to the state's letter. Yeah, that was like a long statement to say we don't want to make a
Pleaded,
statement.
and there have been testimony.
So we'll get this going. Thank you so much, Ike. StreamYard's been really finicky with me for the last 2 days. It does not want to maximize. Like whenever I'm working in a tab that's shared to StreamYard for you guys to see, it just acts stupid.
Okay, so
There
y'all
we
want
go,
to
you
move on
guys.
to
I'll be back. I'll be
intrinsic
listening in the
acts.
chat.
Okay. Which ones? Because there was a set that y'all said there just hadn't been a 403 analysis on yet. And then there was, I guess there were a few that at least somebody, Mr. Ryan was maintaining, were not really intrinsic.
Yes, yes,
Okay.
Your Honor. That's accurate. Back in 2022, the state filed a general notice that they were going to introduce intrinsic evidence.
Mhm.
We then got a witness list on July 31st, which I think was supposed to be one of the final, we can rely upon this witness list. And within that, there were 4 incidents which happened in 2023. So they, one, post date that notice, 2, they post date the indictment. So we've
Mhm.
never received any sort of notice from the state saying we are seeking to admit this as intrinsic. However, that is what it is labeled as
Okay.
on the witness list. So that those
All
4
right.
are what we take issue with.
Okay, got it. And these are the incidents that occurred in the jail generally?
One in the jail, 3 in the courtroom.
Okay, thanks.
And Judge, I'm not sure if Mr. Bassi realizes that we did notice 2 of the ones that occurred in the earlier part of 2023. The stabbing of the person in the jail by Mr. Ryan, Mr. Blaylock, and others, as well as the violation of the Georgia Controlled Substances Act by Mr. Williams and Mr. Adams. And those 2 occurred on January 31st, 2023 and January 18th, 2023, respectively. The filing that we noticed the defendants of those on was November 6th, 2023. There were 2 additional acts that occurred in 2023 during the time that this case has been ongoing. And one was the drugs that were found in Mr. Stillwell's cell. And we've noticed some of the pictures of the drugs and the other contraband, and the marijuana that was found in Mr. Ryan's pants when he was searched in the courtroom.
Mhm. Okay, so the stabbing, that occurred in the jail, right? Okay, and then the VGCSA violation was in court?
It was.
Obviously, drugs in Mr. Stillwell's cell was in jail, right? And then the marijuana in Ryan's pants was in court. Is there another incident that occurred in court?
Not that's on here.
Okay. Ms. Abassi, you had said 1 in jail, 3 in court.
I'm sorry, Judge, that
2 in jail, 2 in court. Okay. Okay, and the argument as to each is that this is not really intrinsic?
yes, Judge.
Okay.
It doesn't fall into any of the 3 categories which would classify it or qualify it as intrinsic.
Okay. Let me pull out my case law on that. Which. All right. What's the state's position on why and how that is intrinsic?
The Bussy stabbing, which is the one I'll start with, Your Honor, involved
I'm sorry, what'd you say? The what?
Oh, I'm so sorry.
I just didn't understand what you said.
Understood. The victim.
Love has been so
was the
soft-spoken
January
with the yeses,
31st
and I'm so
stabbing
sorry.
of
Okay.
Sarah
All
Bussy,
right.
and that's what I
Bussy,
refer to it as. So that stabbing involved several YSL gang members stabbing an inmate at the Fulton County Jail who was
Mhm.
alleged to have messed with Rodelius Ryan's commissary. It involved, among others, Demise McMullen, Javon Fleetwood, Christian Eppinger, Damone Blaylock, and Rodelius Ryan. They all, in concert, held down this person and stabbed him repeatedly, all to protect and to vindicate something he had done to one of their other one of the fellow YSL gang members. It's the way that I
Okay.
see it. So that it seems just, it's what we've alleged in the indictment that YSL members do. They work to maintain individuals ready and willing to preserve and protect the reputation, power, and even the territory of the enterprise through the use of violence.
Okay, I understand.
With respect to the law, we would cite Johnson versus the state, a Georgia Supreme Court case decided September 21st, 2021, cite 312 Georgia 481. And we cited this last week. The Penn site is 491 to 492. In support of it. Okay. With respect to the January 18th violation of the Georgia Controlled Substances Act, this is 2 YSL members on trial for conspiracy to violate the RICO Act through drug distributions, drug use, drug possessions. And while in court on trial, they are passing Percocets, one to another. And we argue one to the alleged leader of YSL while in open court. One of the assertions that we make regarding the conspiracy. We have contraband in the jail. We have stabbing in the jail of YFN Lucci. We have communications in the jail. These types of actions on the part of the defendants are the type of actions that we have alleged in the indictment, and it shows that the enterprise flows from the streets to the jail to the courtroom, and that the conspiracy is ongoing.
And what exactly is the evidence you would be introducing on this VGCSA?
The video of it.
And what all this, I mean, maybe I need
The
to.
video
what does it show?
shows Mr. Adams going up to Mr. Williams while on a break. He's appearing to dap him up, if you will. Mr. Williams puts his hand up under the table. One of our lieutenants goes over to Mr. Williams and sort of says, "Give it here." Mr. Williams brings his hand out from under the table, relinquishes the Percocet to him, and later Mr. Adams is searched. And I think more Percocet pills, more drugs are found on Mr. Adams. And the drugs, the photos and
Okay,
tests of those drugs.
all right. And what's next?
The marijuana was also, so in Mr. Stillwell's cell, there was, on March the 29th of 2023, there were drugs found in Mr. Stillwell's cell that consisted of ecstasy pills, contraband, was it cell phone? A contraband cell phone, for him to have gotten those
Okay.
drugs into the jail while he's on trial for
Okay,
kind of actions involving narcotics and the enterprise and the sale and distribution of drugs through that enterprise. We believe is evidence of the ongoing conspiracy.
okay.
Another,
And then the last one, I guess, was the marijuana found on Mr. Ryan. Give me a little bit more background about what your evidence is going to show on that one.
that Mr. Ryan, while sitting in court, I believe deputies may have smelled the marijuana
Okay,
on Mr. Ryan. And when they went back to try and search or to figure out where the smell was coming from, a large commotion was made. And the
by
deputy,
a large commotion by,
Mr. Ryan, and the deputies found the marijuana attached to, I think, his inner, like inner garments.
Okay.
We have the video.
Okay,
Okay.
we don't know how it got there.
Um,
I mean, on the Percocet, you've got an alleged gang member providing it, right?
yes,
So how about, we don't have anything like that with regard to the marijuana?
we don't have
We just-
provided him with the marijuana,
Okay,
no.
all right.
I don't know how pertinent it is that we have one that's not on here that is also involving drugs that are brought into the courtroom and provided to another YSL member, but that particular one has been severed, so we don't have that one
Right.
on here.
Okay.
Right.
I think that the first three that we talked about are, I could see how those would be intrinsic to showing the allegations that, this is a continuing, ongoing RICO enterprise. Mr. Ryan being in possession of marijuana when we don't know where it came from, that one, I just don't see that falling within. I mean, it shows, what it shows, that he's in possession of an illegal substance, but it doesn't, I don't think it's intrinsic. So I'm gonna rule that one out.
Yes, Your Honor.
The other three,
Your Honor,
yes. Go ahead.
I appreciate the directed verdict that you just gave for one of Mr. Ryan's.
Oh, is that
intrinsics.
one of his? That's not something.
No,
that-
I'm
Yeah.
saying you're
That's not
keeping it out
anything.
without hearing, but from us, but, regarding Mr. Stillwell's,
Mhm.
we have an indictment with 100, I believe it's 191, could be 191 over X.
Yep.
Okay, we also now have a list. At first, we thought maybe they had abandoned these 53 and they were narrowing it down to 4, but no. It's 53 plus 4, 57 plus 191. That's 248, I believe, 248 uncharged events, or not substantively charged
Right.
events in that are coming into this trial. Regarding, the state keeps saying, and this shows the enterprise. Okay, there were apparently, I've seen photos, I wasn't there. There were pills that were recovered from Mr. Stillwell's cell, where he has a cell phone.
Okay.
Okay. There is absolutely nothing about those pills that suggest they were provided by anyone associated with YSL. There's absolutely nothing that suggests that those pills were going to anyone associated with YSL. There's absolutely nothing to suggest that any proceeds from those pills were being provided to anyone in YSL. There was a phone. I have not received any information from that phone that suggests any link at all to YSL. I am
Okay.
not saying my client's a drug dealer, but what I am saying is people that are in possession of drugs, whether it be my client or his cellmate or someone else, are able to sell drugs without being part of a huge enterprise. And
Mhm.
without any evidence that somehow this is linked to YSL, this isn't intrinsic. The test for intrinsic is an uncharged offense arising out of the same transaction as the charged offenses. I don't believe that's the case. Evidence necessary to complete a story of the crime. That is definitely not the case in this scenario. And it's inextricably intertwined with the evidence for the charged offense. I don't believe that's the
Right.
case either. So
I wish he led with
don't know
this.
why
I wish he
this-
started with it.
understand. Thank you
And he
for,
is, and just so you know, Your Honor, he is charged on a separate indictment. I believe it's indicted. If not, it's in a CP case still, but he is charged separately. And that case is pending in Fulton County Superior Court.
okay, appreciate it. Thank you for bringing my attention to that.
Your Honor,
Yeah.
if I may a bit further, the one case,
On which?
really regarding all three of them. I'll
Okay.
start specifically with the stabbing as the state did.
Can I rule on this other one first? Give me just a second.
Which other one?
The one that Mr. Sharp was
Stillwell.
just
Yes, Your
talking
Honor.
about. Okay, so the Stillwell had a cellmate. Is there any evidence as to where the drugs came from, or that it was his, or that the cell phone was his, or connected in any way to YSL?
Well, two things. So yes. Yes, we believe that, I think we have to do body cam research. We believe that the testimony from the deputies within the jail would establish his ownership of it, but more importantly, what we have, I briefly touched on it, was the other YSL member whose intrinsic act that we've not put in here. The pills,
Mhm.
if we call them purple hearts, blue stars, and yellow diamonds, they were trafficking amounts in Mr. Stillwell's possession, and they were trafficking amounts in the other YSL members' possession. That is not on here and that has been severed. They are the same type of pills, and they are a large trafficking amount.
Okay, but
And we know that at least that other one, that
Yeah.
other YSL member smuggled the drugs into the jail, or at least into that area, through the courtroom. As it was described, it was enough in one, it was a pharmaceutical.
Okay, so any evidence that what was in Mr. Stillwell's cell came from that?
Other than it was that they were just alike. If you looked at photographs of it's not like you had all white pills. Like you had the same array,
Blue,
variety,
purple, and
to use just some colors. Like they were literally at least three different colors and three different shapes of pills. And they were the same, three different colors and three different shapes.
This is present day Cat, by the way, speaking. It sounded like Judge Whittaker was about to break down. Is it D12 that did the blue and yellow purple pills song? Like it sounded like she was about to bust out into that. But I did want to stop. I see that Tamika, good to see Tamika. Like seriously huge supporter of the channel and giving me a ton of encouragement outside of the YouTube chat. I want to catch her before she says she's in and out. So thank you so much. Tamika just gifted 5 memberships. So thank you so much. You guys make sure you say thank you in the chat. And then also sent a 5 that says, busy today, so I'm in and out. Thanks, Kat, in the chat for holding it down. Can we do 100 memberships today, guys? And I'm laughing because we just got to 69 on the dot. So I know you guys are going to be like, don't disrupt it. Keep it 69. It's incredible the amount of support you guys are sending while we're doing these streams. I'm super appreciative. So shout out to Tamika. Also got to give a shout out to Left Coast Mana here. Left Coast sends 5 and says, remember when we thought it was a Hilton day to talk? I jinxed it, you guys. It was me. I'm sorry. Good times. You are spot on. My bad, you guys, for jinxing us. And then Left Coast Mana, another 5. So we are up to Angie. I was saying we are up to 69 because of Left Coast Mana and Tamika. Thank you to both. Shout out to Left Coast Mana. And then Angie said, hold on, we're going to clean this up. We're going to keep it PG and make it 70. Appreciate you so much, Angie. And Tamika, thanks for popping in while you're in and out today. We are thinking of you while you're busy. Hope your day goes by quickly. So we're going to continue. I'm going to take day 127 Cat off the screen, and the cat on the screen will now be old Cat from day 114, and we'll see what else we argue that should have been resolved already.
And you can establish that those were YSL related?
Yes, because yes, the
Hold on, holy moly. Holy moly, you guys. Okay. Day 127 Cat is back. Holy moly. Heart of Inspiration just dropped 10. Holy moly. Shout out to Heart of Inspiration. You know, I saw you for a little bit. I opened up the debate trying to watch it. You guys, I used to love the debates. And then I tried to watch it yesterday and just couldn't do it. I couldn't do it. And I saw Heart of Inspiration. Honestly, I saw your comment. You're like, I gotta check out of this. Like, maybe it was from all day of watching Love, but I couldn't do it. So I'm so glad to see you this morning. Thank you for gifting 10. Thank you for just gifting 10. And then Darcy came in with 20. So I think we just hit 100. Holy moly. We are at 105 according to the YouTube counter. Let me update this banner. That is so awesome, you guys. Let me make sure I get you in here. Super, super awesome. And I don't have that banner running, the sponsor banner. It'll be back when we're not doing a rewind. I always like to keep the rewind banner so people know we're not live. But wow, 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 wow. The 69 didn't last for long. So I'm going to update that banner for when we're ready. And also I just noticed I'm an idiot. I dropped Excited Utterance. I thought I was dropping her link in the chat for Hearsay for Days. And what I actually did was I pasted it as a banner. So I'm so sorry if you guys wanted that link earlier. This is Excited Utterance's channel for the Hearsay for Days series. Oops. Oops. Oh my God, you guys. Steph just gifted another membership. And then Steven Satchel gifted 10. And then Chloe's dropping 5. Michelle's dropping another one. Oh my God, I'm so glad that YouTube keeps count. You guys are crazy. We hit 117 members. So I'm going to update this banner. Again, sorry about the excited utterance link. That is in the chat now. 117. And I'm adding Chloe. Chloe, you are in here because you have given so many super chats and now the gifts. Whew. Thank you so much. Heart of Inspiration says 69s never last for long anyway. He. Oh, shout out to you guys. Shout out to this whole chat, the honorable chat and Heart of Inspiration. Steph JK says, proof we have the best chat on YouTube. Thank you so much, you guys. Holy moly. And we've got one more. We're gonna get through this rewind during the lunch. Patina Collective, shout out to Patina Collective. Becoming another member. We are at 118. Let me put up my rewind banner. And let's watch the mess that ensued back on day 114.
When you say those, you're talking about the one?
So
that
if
originally
I'm to accept that y'all have enough that you can make the assertion that the pills that came through some court proceeding to this other person who's not a part of this trial,
Right.
are the same that are in Mr. Stillwell's cell, then what's the YSL connection?
Not the
there?
same pills and the same.
Type, the
Yes.
same, shipment or whatever, the same.
That person was in this trial. That person was in this trial during that time.
Okay, but then being in the trial and co-defendants doesn't establish what the assertions are.
No, it's the not similarities, the exactness of the, like.
No, I'm not asking at this point, like, assuming for the sake of argument that, yeah, these pills all came from the same place. And he, in fact, then what's the YSL tie-in?
Maybe approach with a member of the.
Sure.
Are we approaching? This is present day Kat speaking again. Gwennon, I did miss you. I don't see it. So StreamYard usually stars things and I don't see yours, but I see it in my YouTube panel. So shout out to Gwennon. I didn't mean to miss you. I'm sorry. But Gwennon Garnett also became a channel member. So Gwennon is part of the gang and we are not going to forget Gwennon. Thank you so much for pointing that out. Totally did not mean to miss you there. But holy moly, you guys. And yes. So Tamika, thank you so much, Tamika. We conspired to get that quick 100. Super, super amazing, you guys. And then Peter Ortiz, I got to update my banner. Peter Ortiz just gifted 10. Guys, I think we're at 128 new members today. Which means I think new emojis. I can add more emojis. That's going to be awesome. Peter, good to see you. Thank you for giving 10 people memberships. You guys know the drill. Say hello to Peter. He likes to use the exploding emoji. So if you want to shout him out with the explode emoji, that'd be awesome. All right, going back to day 114, Cat on screen. Look at them talking. Look at them talking. Hilton looks like she's like, why would you do that?
I didn't know y'all didn't have them. They're not up here. Yes, you may.
Thank you.
So are y'all satisfied about, our other bench conference was about the location of that other person? Everybody, I just assumed that y'all.
Okay, are they muting? We're not quite at the bench yet. Love is still trying to figure out her argument. Look at Hilton. Hilton looks annoyed. Oh yeah, this is your bench conference. And you're the one that hasn't approached. Look at Doug looking over. Yeah, it is like a doo-doo-doo type of moment. So they'll still do like bench conferences to keep it off the media. Maybe it's private information or who knows what. Maybe it's just an argument that Love doesn't want on camera. And then Gil had said earlier, judge always leads the state. Will you use it for recollection or for impeachment? Which Love repeats. Love just echoes back what the assist from Whitaker seems to be. Let them answer for themselves on objections. To be fair, if you want this trial to move along, you might need to give Love the assist. The downside, right? If we don't let Judge Whitaker give the assist, we might just have Love buffering indefinitely for minutes, hours at a time. But it does seem like, especially today, with pretty much really any of those social media posts, and some of the stuff with the Yak statements, the Yak interview, Love was just on pause. The judge looked over and was like, well, what are you going to say? Are you going to say this or that? So you're exactly right, Gil. But yeah, the other side, the alternative would be just to let Love stand there and try to think of something. So you got to pick your battle. But it does seem
Out as well.
And that's not to say the defense doesn't know an argument that they want to make, but sometimes when Shart starts talking about things that are more theoretical and descriptive and doesn't jump right to the base. Thank you for the super chat. Same thing, Nika. Thank you for the super chat. And then Chloe Albert's Revenge says that by Love standard,
All right,
her
and
Avon
with
ladies in a
regard to
gang.
the Contraband in Mr. Stillwell's cell, I'm going to rule that out as well.
Okay, nice
and,
win
I mean,
for
we may have another
Shart.
indictment against him at some point in time, and it would all be appropriate to come in there, but not for this case. So that, now, Ms. Abbasi, what do you want to say with regard to the other two?
Yes, Your Honor. Your Honor, actually, the state cited when they discussed the stabbing, the same case I cited, Brown, which had, as Mr. Shard said, those three circumstances. Uncharged offense, which arose from the same transaction or series of transactions as the charged offense. That's actually the topic of discussion in Brown. And in Brown, it was a robbery which happened 1 hour before the charged crime. If the state is going with it's part of the same transaction or series of transactions, then we have a very serious problem with proximity, because the case law is not anything a conspiracy does that happens over the lifetime of the conspiracy qualifies as intrinsic. It has to be closely linked with the others, closely linked with the other charged offenses within the indictment. Your Honor can look at Sanchez Villa versus State, just 341 Georgia at 264 from 2017. Within that case, the evidence the state was trying to present, the court found all of the cases the state submitted distinguishable. And the same is true here when Your Honor goes through the cases as far as being part of the same transaction or series of transaction as the charged offenses. This, like those cases, is attenuated in time. For ones which do have more time in between, they discuss how in those cases, the defendants in their other uncharged acts were in the exact same role. So in one, it was trafficking cocaine as a lookout. In the uncharged, trafficking cocaine as a lookout. There were very specifics linking them.
Were any of these in the Sanchez Villa, either those facts or the cases that are distinguished, either a RICO charge that was involved or a gang enterprise?
I will double check because they go through quite a few cases. I'm going to have to look back through all of them. I think the hallmark of it that we get within Sanchez after they discuss all these cases, the evidence in this case, the Sanchez case, is considerably more attenuated in time and space from the events leading up to the charge offense. So it offers little to help the state. They continue on and say that, well, as far as this goes, we're not in a circumstance of completing the story of the crime. This is just expanding it.
Yeah, I mean, right, it's a different crime, but it might have been a different thing if they were charged with a RICO count in Sanchez. So that to me is what, if these were just whatever the other charges in the indictment are, then I would say, no, but it's the kind of enterprise nature and the ongoing nature that.
And I certainly understand that, Your Honor. I think, however, to say, well, it's part of the conspiracy basically opens the door to anything any defendant allegedly who is a member of YSL does, then automatically becomes part of the conspiracy and automatically comes in simply because it is intrinsic. I think with a lot of this, Your Honor, we're getting close to some due process concerns here. The defendants are on trial for the offenses they were indicted on. That's what they're on trial for. They're not in trial for the enterprise continuing in 2023, that it was still ongoing. That's just not relevant. If the day after indictment, every one of the defendants got together and said, whatever our group is over, and it was completely disbanded and no longer continued to exist, that wouldn't be relevant either. What they're indicted for is what they're on trial for. So here we're expanding. That's, I think, a lot of what's happening with our social media and other things that I guess the state has found afterwards. They're now being tried for things the grand jury never heard about. And that specifically is a violation of due process. I can supply to Your Honor the U.S. Supreme Court case law.
I'm with you on that one. And I am very skeptical of the state's argument that any uncharged, not showing up in the indictment overt act that they offer could in any way support, if found, a RICO count being
I wish we could see the
established.
state
So
right now. I wish we could
unless
see their
I hear
face.
otherwise, which I don't want to hear otherwise right now, we'll take that up another day, but that's not our issue right now. But yeah, I think the state's got some convincing on that count. But with regard to whether, it's intrinsic, I want to get it right. I want to follow what the law says about it. So I think that the key issue here is if we're talking about RICO or we're talking about, a gang enterprise kind of thing. So maybe we could all do a little bit more research on that.
I did look at, in the state's original notice, they cited proposition, I believe that was cases have been in gang and conspiracy prosecutions, gang and conspiratorial activities have been classified as intrinsic evidence. They then cited a number of other cases.
Mhm.
There is not one single case I can find in any case at all where the intrinsic actions come after the indictment, because that's the touchstone of it being intrinsic, that it really is all one thing, that the story doesn't make sense without all of these pieces. And these things hadn't even happened yet. So
Yeah.
it's not possible that they could be essential.
Let me ask you this. If, for instance, and this is entirely a hypothetical, but if this group got together and stabbed this, whatever his name is, Bussy, not because he messed with Mr. Ryan's commissary account, but because he was going to be a key witness in this case. And I'm sure the state, if in this hypothetical, would argue we're trying to send a message that he better not be a key witness in this case. Would the argument be different then?
Well, yes, it wouldn't be, they wouldn't be trying to admit it as an intrinsic act. It could be a crime in and of itself.
No,
separately.
we're not talking about then they get separately indicted. We're talking
Right.
about they're in the middle of this trial. This happens. It's not obviously set forth in the indictment because
Right.
it just happened.
It would be 404B and probably fall into a category there, which would make it admissible for a basis, which was not character. It just wouldn't come in as under intrinsic.
Okay, so you would still make the same argument that it couldn't be intrinsic evidence, even for that, because it occurred afterwards.
Based on the definition I've seen of intrinsic, I don't think it's possible for something which comes after to be
Okay.
necessary to complete the story, unless the story wasn't complete at the time of indictment. That's fundamentally unfair to try them for something which hasn't happened
Okay,
yet.
they're not being tried for it.
Correct.
But okay.
Based on
All
your.
right, well, y'all try to find me some more on point law on both sides, please, if you could. So maybe that'll be my preliminary ruling, subject to revisiting, okay?
And Judge, there was one other thing. I don't know that it'll have any bearing on the court's ruling, but in that instance where Mr. Stillwell, where the drugs were found in Mr. Stillwell's cell, there were, Miss Hilton pulled up the photograph that I asked her to, and there was a shank.
Is the shank inscribed YSL? Then
No,
it doesn't,
no.
I mean, it makes Mr. Stillwell look bad, but it's not intrinsic.
Yes.
Okay.
Your Honor,
Yes.
if I may,
Yes.
before you make a decision on the one alleged intrinsic act that was referenced by the state involving the supposed passing of a Percocet pill from Mr. Khalif Adams to Mr. Williams, I would ask that the court
Clarify
at
the
least
other
go and
Adams.
take a look at the video that was referenced by the state. I think it's instructive. I also think that well, fortunately for us, paints a different picture than was recited by Madam Prosecutor. I think the events did not occur in the manner that she referenced. I was present. I was sitting right next to Mr. Williams. I think the video will show something being passed to Mr. Williams, not him hiding his hand underneath the table or bringing it out and then giving it to the deputy, or the deputy saying, give it here. It didn't happen that way. And I think that goes into the analysis of exactly what happened.
All right, why don't you just tell me what you recall or what you think the video shows?
Sure. Well, what I recall, and what I know happened, because I was
Okay.
sitting right next to Mr. Williams in the front of the courtroom, is that there was a break. Mr. Adams, who was sitting in the rear part of the courtroom, came up, and as he was going towards that door, goes as though he's going to give Mr. Williams a high five or a dap or something like that, and put something in his hand. There's a deputy who's standing about 2 feet in front of Mr. Williams. Mr. Williams looks surprised. Mr. Williams has it in his hand and puts it down on the table immediately. There is no putting hand under the table to try and conceal it. The deputy who I was within earshot of did not say, give it here. Mr. Williams looks at it and puts it down on the table, and that's it. And at which point another deputy sees Mr. Adams and either takes him. I don't remember if they took him in the back or brought him back here.
Okay.
He was searched in the back, as I understand it. I think court recessed after that because of those occurrences, but that's how the incident actually occurred.
Okay. Can y'all send me that video?
Yes, and
Okay.
the deputy, the lieutenant would also be a witness to what I'm saying.
All right, well, I mean,
version
I would
I'm-
imagine the video shows what happened. so.
It does.
It does indeed speak for
All right,
itself.
well, we'll come back to those two. All right, so that takes care of the allegedly intrinsic, but according to the defense, can't be intrinsic because they happen later in time than the indictment acts. What about the other intrinsic or allegedly intrinsic acts that there has not been a 403 analysis on yet?
Can I just add something to the last? Your Honor, can you ask what the prosecutorial need for this is?
I can, but with intrinsic acts, that's not part of the analysis.
Yes, 403 is the
Well,
analysis.
403.
You need a balancing act.
Which
So-
Yes, you
includes
do.
prosecutorial need, waste of time, prejudice, substantial prejudice outweighs any appropriate value. But to me, this is a big case. It's
It
been on a
is.
long time, and now intrinsic acts. So yes,
Okay.
I don't know how much the state needs to prove that Mr. Williams was knowingly or unknowingly given an alleged item. I'm not so sure what the crime lab came back, but I can't answer for that.
Has the crime lab come back?
That may be true. I don't know. I don't remember.
Okay. All right, so we now have a 403 argument or objection.
So, Your Honor, I think that the court had it right regarding the need to analyze, looking at the prosecutorial need. If it's a 404B act, then that would be a situation where we would be looking at the prosecutorial need, but it's not. We're alleging that it's an intrinsic act. And looking at 403, Your Honor, the analysis is it substantially more prejudicial than probative? And it's simply not, is our position. He's alleged to have, Mr. Williams and the other indictees here are alleged to have conducted drug transactions. One of the acts on the indictment involves
Them having a trafficking amount of drugs, right?
at least one. So we would argue that it in no way can be viewed as substantially more prejudicial than probative, and it's intrinsic. But we're pulling up the video too.
Well, I mean, I guess is it intrinsic is yet to be determined based on the time period, but
Your Honor, this
Yes.
is not really my argument, but I have got to weigh in here
Oh,
on
please
this
do.
issue. Yeah, thank you.
Go, Doug.
I'll get my 5 minutes in. The 403 analysis is not limited, as you know, to is it more prejudicial than probative? As Mr. Steele said, you also have undue delay and waste of time. And those are factors
It's
as
like my
well
motion.
that I'm not surprised that the state ignores because they seem to have no concern for delay or waste of time. So those are factors that the court should consider as well, Your Honor.
all right, thank you. Okay, well, I will
Keep
give you
pressure
a
cooked
couple of
there.
days to, if you can find more on point law, provide that. And if not, I'll just have to go on what we've got and make a decision. I'll take a look at the case that got cited and the cases within that. And then if need be, do the 403 analysis. I mean, I'll get to that, but okay. So that's those. What about the other intrinsic acts that 403 hasn't been done on yet? Did y'all is there a list? And is it? And I can't, let me see, I'm not sure quite who filed that one, or maybe Mr. Short just told me there are some that the 403 hasn't been done on yet. From the November 6, 2023 filing, but I don't know which of those.
And some of them have already been, so Judge Granville made an initial ruling
Right.
on one day on 1 through 3. And then throughout the trial, we dealt with and admitted evidence on number 4.
So now
It's
Glanville's
not right
ruling
in
should
front of me.
stand.
The filing on November the 6th, 2023.
Yeah, I
Of
think
the-
I've got that. Give me a second to locate it.
And thank you to Good Vibes and for always, forever for life for becoming members. Glad to see you in green.
Okay, yep, I've got it.
So, Your Honor, my recollection is that we began discussions on this one day a long time ago.
Okay.
And I agree with the state that they have presented evidence on some of these incidents, some of these acts. Your Honor is saying that we haven't done a 403 analysis. I don't believe.
Only
we've done-
because y'all, that's what I thought you had said to me.
Okay, if I said that, I believe I misspoke. I don't believe
Okay.
we've done really any analysis on this list, meaning
Okay.
I don't believe, speaking for the people on this side of the room, I don't believe that we are conceding that they're intrinsic.
All
in
right, so we may
getting
need
before
to, starting with number 5, look at all of them.
like, Your Honor, I thought we were going by the state's July 31st witness list. So that would not encompass all of these things on here. That witness list went through by what offenses it was set to prove. or
This
acts.
one,
Yes. So I was relying on the witness list when filing motions in limine of what they actually intend to prove. I thought that was the whole purpose of,
well,
Judge, I'm not sure if Ms. Abbas, we filed this November
Yeah.
the 6th of 2023, and I know she wasn't here at that time, but we, this is the argument I think that Mr. Sharp made. This is the one that he sent out with his objections. This is the filing. So this is the one that we're addressing.
okay, well, I mean, if for instance, you don't intend to use, 20 through 30 anymore, tell us that. If you still think you intend to use every one of them, tell us that.
A lot of them have already been completed, and there have
Okay.
been testimony, there's already been
All right.
testimony on a lot of them.
Okay, so can you tell me right now?
Yes.
Which that's true for?
Number 4, the 5/12/2013 aggravated assault and home.
Yeah, I mean, I've got it right in front of me, so if you just want to say number 4, that's fine.
Number 4, number 5.
And you said a ruling had already been made on 1, 2, and 3?
Yes,
Okay.
we didn't admit them, but they were. Okay, so we did not admit evidence of 1, 2, and 3. All that we did was address them initially. We didn't admit evidence, and we don't intend to, but those are the only 3 that were addressed initially.
And you don't intend to, so you're not intending to introduce those 3?
Right.
Okay, well then we'll cross 1 through 3 off the list. Okay, 4 has already been admitted, 5 you said has already been admitted.
Right.
Now what?
Also, as it relates to 7 is one of the overt acts listed. The reason that we included it here is that Shannon Stillwell's name was not in the indictment itself
Okay.
on that overt act. The same as to number 8. What? I said the same as to number 8.
Okay, so those are listed, those acts are listed as overt acts, but Mr. Stillwell is not listed in the indictment when
Right.
you're talking about the overt acts. Okay,
Correct.
all right. What about 6?
6, actually, so 6 is gonna be talked about. It has already been talked about some, and it'll be talked about some more.
Yeah, I thought it had already been talked about some. So I mean, that's in the past, basically. 7 and 8, given that they're overt acts, adding Mr. Stillwell to them, that can still come in as intrinsic. What else?
10 has already
About
been,
9.
9 has not been talked about.
And do you intend to still present evidence of that? I mean, you do at some point need to streamline your case.
So we can strike off number 9.
All right.
I believe. 10 and 11 have already been alluded to, and in fact, 11 has been discussed by the witness who's currently on
Okay,
the
so
stand.
those are already in.
Yes, and I think that the court at first asked me to tell the court which ones that we. had
Well,
already-
you know what? Why don't we just walk through them the way we're doing now? Because you might decide on some other ones that you don't need those.
All right, so Hill Street there will be testimony given on that through Detective Dennis.
Okay. And
Oh,
who's
he already
involved in
talked about
that?
it, Ms. Hilton has
Okay,
reminded me.
So that's already in also. Okay.
Number 13, a witness has already talked about,
Okay.
Mr. Copeland on the stand. Number 14 has already been testified about.
Okay.
We've taken off number 15.
Okay.
Number 16 has already been testified about. Number 17 has, we've already presented evidence on.
Okay.
Number 18, we've already presented evidence on. Number 19, we intend to present evidence on.
All right. And tell me, is that like part of the gang rivalry leading up to Mr. Thomas's? I mean, I'm just looking at the date for that, or why is that intrinsic? Why is that a part of the whole story?
Already.
We've talked about it, or y'all have talked about it.
She's right. We did.
I'm not aware
The aggravated assault at Trestle Tree on the 8th.
What case is that?
The aggravated assault at Confederate Court is
I'm aware of that, but
through Detective Dennis. I believe that when he gave, I'll have to go back and make sure, looking at our, at the flip chart that we made while he was on the stand.
Okay. But would this be part of the back and forth that y'all assert led up to?
It was part of, yes, part of the shootings that they went back after the murder of Donovan Thomas and found out about. So that when we say back and forth that led up to it, they started investigating those shootings after the murder of Donovan Thomas.
Okay.
And this was one of the ones that
And this is a shooting of whom by whom?
at Trestle Tree, which would have been Ifgane territory, we allege by YSL members. But
Okay, and what evidence do you have of that?
we didn't. Okay. So, and just so that Mr. Sharp has that, it's for 150080094. We've already put the CAD report in the 911 call in.
okay.
Okay, well, that pretty much
Well-
sounds like that's it then.
Well, I don't agree. I mean, what's I think obvious right now is I've been very involved in this case.
Mhm.
I don't know what this January 8th shooting is. I'm asking Miss Love. She doesn't know. So I'm trying to figure out how anyone could argue, if no one even knows what it is, how it's so intrinsic to this case.
Yeah, I don't know if she doesn't know what it is.
Well, I mean,
period,
I keep
or if
asking,
She
I'm
just
giving
doesn't
a-
know right now what it was. So who is alleged to have done this? So, or is this just a general, we, the gang experts, found out about this and we think this was a part of it? It's so, okay. Is there going to be more besides what's already been
No.
testified to?
No.
Okay, so it's already in. Okay,
Number, what number?
20.
20. We have already heard testimony on this one.
And that's all we're going to hear as to
Yes.
that? Okay.
Yes. And we've already heard testimony on 21
All right.
and 22.
Mhm.
We're not introducing 23.
Okay.
24, we've already heard testimony about, and we will hear more. This is actually where we got that video from that we mentioned, Mr. Sledge, that's in the folder for Mr. Sledge.
Mhm.
Number,
So, hang on. What else is going to come? I mean, great if the video happened to be from there, but what else is going to come in about this ag assault criminal damage?
well, Mr. Antrevia Smith is one of the witnesses that we've listed,
Mhm.
and her testimony.
That's a victim?
Yes, that's whose
Okay.
house it was.
All right. Okay. Go ahead then. 25.
This is January the 28th.
And the delegates of life, I'm not sure who Nikki Barnes is. So I missed the context of your comment.
I thought we'd already
So
issued
back to the blue magic in the pills.
Kendrick.
But I didn't know who Nikki Barnes is by name.
1502. We've already introduced evidence of, with the exception.
And FFS says we're running on.
Hilton's reminded me that with the exception of Shannon Stillwell's involvement in the Lil Wayne bus shooting, it has come in, but it was added here because Shannon Stillwell's name is not on the over.
All right, that's fine.
That Love is running on Windows XP with dial-up.
Is coming up, the shooting at Club Crucial preceded the shooting at Dell Drive and Drew Drive, and that's duplicative of 7 and 8, so 30 through 33 are the same.
So, I'm sorry, 33, 33.
I was saying 7 and 8 if the court was just.
Oh, okay. So they're just listed on here twice, basically. Okay.
34 is already.
So I can just cross off 33, 33, right? Because we've already covered them. Okay.
34 has already been testified about.
Hey, did the prosecutors have to do their training this morning?
Okay.
Was that why they were late?
36, we don't, well, actually. I asked the court to allow us to come back to 36. I believe that there are ruling may have been made on that.
Okay.
At first,
Right.
I want to check. 37's already been testified about, 38's already been testified about. 39, we don't intend to introduce evidence of. 40, we do intend to introduce evidence of.
Okay. That seems pretty intrinsic.
$41. We were taking out 41, this was been 7. Oh, Judge, I apologize. As far as
39 comes in, I was thinking of another incident. 39 is coming in. That is what led to the arrest by Mr. Kendrick and Mr. Arnold with the firearms that Mr. Kendrick entered a guilty plea to that involved his plea colloquy that we spoke about earlier. But the fact that Mr. Arnold didn't want to identify Mr. Curtis or testify against him at trial is not, we're not putting that part in.
Okay, but that Arnold was assaulted by
Mark.
that you want to come in? Is that what you're saying?
Yes. That is what led up to the arrest of Mr. Kendrick and Mr. Arnold. They went to retaliate. So my apologies. That's 39 and 40 coming in. 41 being taken out. 42, we don't intend to introduce evidence of 42.
Okay.
43, we do intend. 43 is coming in. Well, we intend to introduce evidence of 43. That's tied to the armed robbery that he's alleged in the indictment to have committed.
Okay.
On October the 11th. 44 comes in because that we believe is the motive for the murder. That is the last murder on our indictment.
Okay.
45 similarly is tied to the Shamel Drinks murder. So we would argue and would ask that that be allowed to come in.
All right, so present day Cat is back. This is me on the screen. There's only it's only love rambling on until this finishes out. We pretty much got through it. I'm gonna switch my banners back. We're coming back to present day. We're gonna get back to present day law and crime stream. And get the old banner again. Thank you so much. Just like during lunch too, just like an incredible overwhelm of everybody gifting memberships, becoming members. Super awesome. And yeah, so if you're just coming back, if you went to do something else for lunch, what you just saw on the screen was a rewatch from day 114 relating to a lot of the same arguments we spent a ton of time on this morning, that the state never filed a written response as they were supposed to back then. Yeah, who's the real cat? Who is the real cat? It is me now, time traveling. And I'm sure since there's no jurors, no defendant issues, everybody's in the court for these arguments, we probably will get started right away. But who knows? Thank you to Mark the paralegal for becoming a member. I'm looking at what you guys are saying here. Everyone's like, oh no, more love talking. Mercedes suggests a KNW emoji, a gang emoji. We could do that if you want. It could be like what you guys use when you enter and exit. That's a good idea, Mercedes. Thanks for the 2. Chloe says, gotta get the gang numbers up for cuffing season. Oh no. Oh no. Yeah, because what the state's argument is that Trivia, that was, Mounk Tounk fighting over this girl. or fighting to help his friend with a girl, like whatever the story is, the idea is that it's the whole gang. The whole gang is cuffing. States theories. Thank you so much, Chloe. Kimberly Parker became a member. Shout out to Kimberly. Wayne is saying hello. Well, chat if you want to say hi to Wayne back. Good to see you, Wayne. Peter Ortiz. Peter says, Kat, I love hats and caps. How many do you have? Not enough. I used to have a ton more hats when I lived in New York because I could have winter hats. So I had a bunch of different like beanies, and I'm a Vikings fan for football, so I still have like a winter hat. It's like knitted and it has the braids, like Viking braids. So I have one of those. I used to have way more hats where I lived in a colder Four Seasons type of environment. In Florida, I just have regular caps, probably like 25. Mostly just different colors, or as you guys have heard me say, every time Diane Fossey Foundation release a new hat, I get it. They support guerrilla conservation efforts. Super, super awesome foundation. So a lot. So hat tip to you. PJ says, I'm so glad the algorithm led me to your channel. Well, welcome, PJ. Good to see you. Good to see you. I love when the algorithm gives me something good. As Satchel says, RBG, Rico Brady gang emoji. We could do that. That's a good acronym too. People will think it's red, blue, green. So it'll be incognito. It'll be a little below the radar. Yeah, we might have to do that one. La Mustache White Gang says, Whitaker was so different only 2 weeks ago. Now she's like, love. I think L is for love. But yeah. Yeah, you guys noticed that in the throwback too. I mean, I think my own comment, I was like, why is Whitaker letting that go? So interesting to watch in retrospect. Oh yeah, Liz. I remember everyone used to want to go and get the custom embroidery on. Go to Lids to get their hat embroidered. Heck yeah, I haven't seen a Lids in a long time. Although that might be how shopping malls are kind of like fizzling out. The mall close to me, like half the stores are just closed and empty. So that could be a sign of I haven't seen Lids in a while, because shopping malls are just kind of becoming relics of the past. Yeah, that's right, Gwennon. Skull. Lillian, thank you for the super sticker, Lillian. Donna Hallman says, this wit makes a giddy up clicking noise. Was she? I wouldn't be surprised, but her giggle is giddy, for sure. Thank you, Donna. Mark in Texas says, State and Page went for the poor prosecutor must prove beyond a reasonable doubt BS. Yeah. Like, oh no, they have a burden that's supposed to protect the constitutional rights of individuals. Boo-hoo, sucks for them, let's help them. Like, that's not how it's supposed to work. This driven by especially conservatives like me voting in former prosecutor as judges, leading to the state of our jurisprudence, not sure how to fix. Yeah, and I agree. And I think it's also a law can take a long time to catch up, especially things with case law. We've got to get something to an appeals court and then get a decision, and then maybe it keeps getting appealed up higher and higher before we actually have case law that decides a novel issue. And so it can take years and years and years for the law to catch up. Because of elections, it can take years and years and years for judiciary issues to catch up. Same thing with legislation. And we're coming out of a phase, I'd say really up through the late 90s, maybe early 2000s, where we started to finally phase away from the crime and punishment era. But 20 years after, we're starting to switch away from that mentality and looking at incarceration as something that should be punitive and do the crime, do the time. We're still playing catch up with undoing all the statutes that, 3 strikes laws. Judges that have a firmer hand, firmer ruling. Prosecutors that, have this mentality that a win is a checkbox on the conviction card rather than the right outcome for justice. So I think we've reframed what we think the incarceral system is supposed to be for philosophically about 20-25 years ago. And it's the law, the rules, the people, the butts that fill the seats, just tons and tons of ketchup. So I think how to fix is patience, but proactivity combination. Being proactive won't change it overnight. But not seeing the change overnight, thinking it's not going to change, will stop the proactivity that's needed to keep the change coming forward. So really, really sucks. I think it takes a lifetime to really see a change in the criminal justice system. At least several decades. Great food for thought, Mark in Texas. Chloe Albert's Revenge says, I started a garden gang. We rep pink and green. We claim our berms and run old ladies off our corners. We claim all the seeds of all pink flowers around. Shout out to Pink. Our sign is a curtsy, old sap life. So my garden, I still have like my tomatoes and my herbs. My balcony garden got taken over by aphids. So I had some garden failures this year. My garden gang failed and lost the war to the aphid gang. So I had to get rid of I had like cucumbers and some squash stuff going, and I thought about ordering ladybugs and just setting them free in my balcony. I was like, no, I don't think anyone wants to deal with that. So I succumbed. We lost the gang rivalry. Shout out to the gardeners in the chat. City Gent gifted 5. Shout out to City Gent. Let me update this banner. And in the meantime, thank you, Steven Satchel, for the 2-minute warning. They are late coming back. We could have finished out that last 2-3 minutes of love going on and on if you guys really wanted to. I think most of the chat was like, no more. Let me update this. We've got, and I hope that court audio comes back in before Hilton sits down. It's time to get the squeak counter up to 4. So we're at, holy moly, 135 members. Dun, dun, dun. Oh, I see the camera shaking.
Gotta remember to turn it off again when you leave. Which maybe it's just gonna be an issue at breaks. I don't know, but I don't know.
Microphones?
Just, I guess, try to turn it on and turn it off as you arrive and leave the podium area. All right, Miss Love, I appreciate you sending electronically the communications between the state and the various attorneys whose clients have pled. However, I think for me, it's just going to be easier if you can print them out and give me a hard copy, and I'll give you if you can just have those to me by Monday morning, that'll be fine. But I just think it's just gonna be easier for me that way. And just, and I didn't go through all of them. I started going through them, but make sure that if there were a couple of emails that, and it was like well into the string. So I'm sure if I got to the original email, the attachment would be there, but just make sure I've got the relevant attachment too. Okay, so I'll just deal with all of that after you give it to me in hard copy form on Monday. All right. Did y'all get an opportunity to try to come to any sort of an agreement, if there is any, on those items 451Y through, I think it was 455 or so, and then 460Y?
Your Honor, it was not an intentional disobeying of the court's instruction. What I was doing was the state's position is slightly different than it was with an argument for why.
Okay.
And whenever the court allows, I'll address it. If you want me to start now, I'll just start now.
All right. So did you give a redacted copy to the defense, or you just think whatever your new position is might change everything?
It will change everything. And
right.
and I did also, the thing that I'd asked Ms. Winfrey for that she so kindly provided was what exactly the objections were to the exhibit so that I could address them in turn. What I recall specifically I believe that it was Mr. Stillwell who made the initial objection that.
Hang on a second. Can y'all try to be a little more quiet over there so I can hear? I don't know who it is, but, oh, that actually reminds me too, before we get into that. Just a reminder to everybody that there's not supposed to be any eating in court and that the defendants are not supposed to be on laptops. Okay, that has not changed since I took over this case. All right, go ahead.
My recollection is that Mr. Stillwell's attorney is the one, Mr. Sharp, who originally specified a portion of one of the exhibits that he felt should not be allowed or presented to the jury because it contained information he thought was overly prejudicial. If I'm not speaking correctly, I'm certain he'll correct me where I'm wrong. But other than that, I was wanting to make certain I heard all of the objections so that I could speak to them. But if my because I'm going to make a proffer to the court.
Okay, it would be a lot easier. I think part of their position had been until we know what the state's actually proposing as the redacted exhibit, it's hard to make objections. So are you ready to share that?
Yes.
Okay.
Yes, I'm ready to address
If you would
it
do
all.
that, that might help the
So, Your Honor,
court and the
on what theory the state would be seeking to admit out-of-court statements?
That was
Stop.
part of what I intended to address. So
Okay,
I'll just
well, let's all get a copy of what it is we're.
They're not redacted. It's the ones we gave them. So the ones that I have previously identified.
Can I have a hard copy of them? Because that's another one of those things that if I'm having a look on the electronic, it's like embedded within several emails
Yes.
before I ever get to what I'm supposed to be looking at.
Yes, Judge. So
Thank
what,
you.
what I'm gonna do is just give to the court my, the copies that I tendered. And I'm gonna speak from my notes as to, what it is about them and why it is that I believe it.
All right, well, hang on. Laura, can you have the substitute JA come down here and grab these and make some copies for me? Please, thank you. Because I have a tendency to write on things once I get them. I'll try not to do that until I get my copies, but. If you'll come around here, that way I can actually reach you. Thank you.
You're welcome. And what, for the record, I have given to your honor, 1AS, which was the plea agreement that had been tendered at Mr. Sledge's plea. I've also tendered 444 Yankee, which is the document we were referring to. That is an exact duplicate of that. 451 Yankee, which was
Yeah, I mean, I know what they all are. So 451, 2, 3, 4, 5, and 6 should be, yeah, and 6, and then 460.
Yes, Your Honor.
Okay.
Your Honor, would the court permit me to take my seat so that I can read it?
Yes, you may.
Thank you. Your Honor, starting with Mr. Sledge's testimony, the court and I think everybody else is aware that as we referenced State's Exhibit 1AS or 444, my particular question to him after he started talking about his truth and his ability to tell his truth was using the guidelines if a acknowledgement that you signed.
Yeah, I remember. We don't have to like belabor the point.
Okay.
He picked out several and listed the ones that he said were false, and they were 3, 4, 5, 6, 7, 8, 9, and 16.
Right. With the exception of about 4. Right. And then he said that he understood none of the sentencing
At the time, yeah.
acknowledgements at the time. So, Your Honor, under 24-6-607, OCGA 24-6-607, Your Honor. impeachment by contradiction.
Well, that's not impeachment by contradiction.
Well,
That's who can impeach.
so as I'm reading, and I know that it's who can impeach, who may impeach.
It's a different one. 621 is impeachment by contradiction. A witness may be impeached by disproving the facts testified to by the witness.
Right. The reason that I reference that only is because it was in the book that I'm reading from. There's a section that I'm looking at. So particularly a witness may be impeached by contradiction in several ways. Close questioning to elicit concessions of errors in testimony during direct, questioning a witness about the substance or implications of evidence already produced during the case to suggest contradictions, confronting the witness with his or her own contradictory prior statements, or calling another witness, or introducing other extrinsic contradicting evidence. Generally speaking, the admission of extrinsic evidence for contradiction impeachment is restricted to non-collateral matters, so that evidence that impeaches by contradiction and is not collateral can be both substantively admissible as well as admissible for its impeachment value. And that is coming from Baylor, Behler versus Hanlon, Hanlon, 199 FRD 553. And then the parenthetical is surveying numerous commentaries. Judge, with respect to Mr. Sledge, the reason that I began my statements to the court about what it is that he said, and will then go into what his lawyer said. When I asked his lawyer about plea negotiations on the heels of Mr. Sledge, not just saying he was told he could get up and tell his truth, but on cross-examination, he was asked repeatedly through the use of allowable leading questions. These weren't your words. You didn't write it. You didn't understand it. You didn't know what you were signing. You felt like you could come in here and tell your truth. You signed it regardless. I'm not directly quoting, but essentially, even though it wasn't true, you signed it. And things of that nature were elicited during cross. You signed it because you wanted to get out to go see your sick mom, things like that. You were in Fulton County Blues. That's the only reason you signed it. These aren't your words. These are only the state's words. So all of those questions were intended to attack the credibility of the veracity of the statement that Mr. Sledge made on December 28, 2022, when he signed the plea agreement. And Mr. Sledge acquiesced to all of those attacks, essentially asserting through his sort of obfuscations and running back and pulling back my truth. I don't understand. I don't recall. I don't remember saying that. That isn't true. And his pointing out at the state's request the factual acknowledgments that he now asserts were inaccurate or not completely true. He allowed himself and the cross-examining attorney to, in front of the jury, completely question or to undermine the credibility of the statement that he made and his own credibility at the time that he made the statement. So as the court has already instructed the jury that the inconsistent statements of a witness are also substantive evidence that may be considered against other persons on trial. Can the court hear me okay?
Yeah.
All right. So as the court has already instructed the jury that it can now consider that statement as substantive evidence, what we've seen is an attempt by the defense to destroy the jury's faith in the credibility or veracity of that statement made by Mr. Sledge on December 28, 2022. So when questions were posed to his attorney regarding Mr. Sledge's understanding of those acknowledgments and sentencing agreements, on the one hand, after he made clear that though he's a friend of both sides, he's a defense attorney through and through, Mr. Wright, though he did clear it up, he seemed to, his answers on cross-examination, there were some things that were not true. There were some things we didn't agree to. He was kind of vague with it, and it took belaboring point by point for him to even acknowledge, hey, number 3, number 8, these are the only 2 anybody took issue with. So at this point, Your Honor, I believe that the iterations that were presented to Mr. Wright and to his client per his words are important because it is further evidence that corroborates Mr. Sledge's understanding of and his understanding of the final plea agreement that is 18S and 444Y, and his ability to effectively engage in and have an active hand in that final document that he signed on December 28, 2022. It points not only, it demonstrates not only the inconsistencies of Mr. Sledge's testimony, but his outright perjury regarding his purported lack of ability to have any say in what that final document asserted that he signed. It is illustrative of the fact that he actually did have the ability to tell the state what he felt wasn't true and what parts he wanted changed. And I think that our position is that it is relevant in showing or allowing the jury to judge the credibility of statements Mr. Sledge has made on the stand versus the credibility of the statement that he made on December 28, 2022. The statute that I cited earlier, it substantiates our position that the representations that Mr. Sledge made under oath on December 28, 2022 were part of a long and detailed negotiation and refinement that Mr. Sledge himself took part in. I think at this point, 24-1-104 might become relevant. That's the one I brought up earlier that didn't have any bearing on what we were talking about. But in as much as 24-1-104 speaks to the code section not limiting the right of a party to introduce before the jury evidence relevant to weight or credibility, we believe that this particular evidence allows the jury, it is pertinent evidence that they should be allowed to see, to understand fully what was put before Mr. Sledge, what he did dispute, what he did not dispute, and what so that they can compare it with what he finally agreed to
and make a better determination about the truth of the statements he made on December 28, 2022. I think that the argument that some of the statements, the allegations made by the state, those are things that one way or another may be asserted in any event. For instance, they caught nut down bad is a statement that we know is going to come out either through the person that said it, the person that relayed to law enforcement that they said it, or in his statement to police if he lies on the stand. These aren't matters that are so prejudicial that they should be kept from the jury. These iterations, if you will, the defense wanted to have us reference part of them, but pointedly objected when I attempted to have Mr. Sledge show or point out differences between a previous iteration and the final version. That previous iteration was not circled there. It's one that I have because I did not tender it as a marked exhibit. They actually objected to my calling it a previous iteration. And I think in attempting to keep from the jury, not just the previous iteration, but the number of them and the changes that were made and requested, and the changes that were not requested, as is reflected in 460Y, we're keeping rather from the jury very relevant, pertinent evidence that in no way substantially prejudices either defendant through its admission. So I believe that an instruction that these are assertions made by the state, essentially questions that they ask the witness, then defendant, are these true? I initial them if they aren't, tell me what changes need to be made, and that they are not to consider as true from this witness or take as statements by this witness anything that doesn't appear on state's 444Y, and that they should look at state's exhibit 460Y as substantive evidence of the defendant through his representative of what he was calling true and not true at the time that the state presented him the iteration that came just before it. So it allows them to put in context Mr. Sledge's factual acknowledgments and sentencing understandings that he signed.
I'm gonna get copies made of all of these.
Yes, Your Honor.
All right, so just one. Oh, batteries, thank you. All right, I've got some batteries. If
Oh,
you
did they
think
go in
that
here?
might help with- I'll just put them up here.
Okay.
It seems like your mic is out and I need batteries. I don't know whether they take double A or triple A.
Double A over here.
All right, got a few of each. I'm just gonna set those right there.
All right, so I think that, there's the 444Y one, which is the signed plea acknowledgement. That's sort of a separate type than all of the rest of these correspondences back and forth. And are you at this point saying, just so I understand, that like as to 460Y, you don't even intend to redact it at all?
No.
All right, help me understand what you're saying.
As to 460Y, I wanted to redact everything except the one email that Mr. Wright sent. I want to take out everything else before. I even think I included twice in that 460Y, the same email. So I would like to redact out all of that except the email from Mr. Wright to me on December 27th at 8:43 or thereabout at night, wherein he is making statements for his client. So they are statements of his client that number one is okay, number two is okay. And I say that under, I
I would call it an adoptive admission, but he is
Well,
an
It's
agent.
an agent,
Right.
yeah.
So he is stating, his client is stating, number one is okay. And in order to know what number one is, the jury needs to see what number one was that I sent to them, which would be the exhibit directly preceding, which I believe is 452. If I'm wrong, I'll make that correction. But the jury should see 452, wherein Mr. Sledge says, that's okay. They should see whatever he wrote about 450, about number two.
Let me ask you something. I mean, is he really a party opponent anymore?
He
He
was.
But is he now? Because admitting it in this trial now, is that an admission by a party opponent?
Oh, you mean in terms of the?
You're saying, this is a statement by Mr. Sledge's agent, which it is, but would that get admitted under the admissions by a party opponent exception to hearsay?
I wasn't admitting it under
Okay,
that.
so-
I was just saying they are statements of Mr. Sledge.
Okay, all right, but under what exception do they come in?
They are Mr. Sledge's statements. He is a witness who was on the stand, who was subject to cross-examination. So inasmuch as they are inconsistent and contradictory to the testimony that he gave.
Okay. So I can see 444Y coming in as a prior inconsistent statement because he definitely testified inconsistently once he was on the stand to what he said in that document, which admitted as factually true all of those things that he initialed.
Right.
So that's a separate item, and I'll hear argument on let's deal with that one. 444Y.
Is it my turn?
Okay, so don't talk about the rest of them until we get past.
Not yet, because I think this is kind of separate than the rest of them.
Okay.
Because it's a different type of document. So do you want to say anything else about that? You saying it's a prior inconsistent statement and it's impeaches him by contradiction.
Yes, and it corroborates the state's position and.
Well, I know why you want it.
Corroborate the state's position is
That-
not a hearsay exception.
Right, I understand that. Yeah, so why is that not come in
Okay.
as a prior inconsistent
Your
statement?
Honor, first, I just have to address one thing.
Okay.
And I'm sorry, I'm not trying to be a whiner. This is exhausting because every time we are on the same page and Your Honor seems to direct us, things somehow get relitigated. We were up at the bench and we all looked at 444
No, 444 is a different one, but yes, 451 through 6 and 460.
Are we talking about the emails right now? Or are we talking?
No, what I wanted to talk about right now is the actual final plea
Okay.
acknowledgement.
So I'll address that.
Okay,
We all talked about this and we determined what would be admissible as prior inconsistent statements. And the state was allowed to read and confront, and he acknowledged that he signed. So he never said he didn't sign those things. He explained it. But those factual acknowledgments on the 1AS, which I think is 444Y, were read into the record and fully litigated. And we not only heard from Mr. Sledge, but then we heard from Mr. Sledge's attorney for a day. And the whole process of how everything happened was covered ad nauseum. I think the jury gets it. And there's nothing that I would understand to be gained by admitting the paper copy of what was testified to and discussed over a week with, this gentleman and his lawyer on the stand, however many days it was, that hasn't already been covered. Additionally, Your Honor, of course, my stance would be, if it were to be admitted, it would not go back to the jury because it would be continuing witness. It would be, signed statements, written statements, and the idea that somehow, well, that deals more with the prior versions, but
Yeah, let's
you
not
know,
get to that.
yeah, I won't get to that yet, but we've discussed this, and now we're back to arguing about it again.
I don't actually know that we discussed 444Y1AS.
Well, the state sought to admit it at one point, is my recollection, and you instructed the state to ask about the ones he was denying, and they confronted him, and they said, "This is what you're denying, factual acknowledgement." I'm using an example. 3, and then it was read, and then it was discussed, and then we went from one to the other to the other. The state was certainly not rushed in their examination of Mr. Sledge. So all this has been covered. There's no need to admit the document into evidence at this time. And it's cumulative, but also it should never go back to the jury to begin with. So I don't even know what purpose it would serve at this point.
Well, we can deal with that later, what goes and what doesn't go and what's subject to a continuing witness objection. But it's definitely a prior inconsistent statement. Y'all were given an opportunity to cross him on it. He was given an opportunity to explain it. It can come in as extrinsic evidence.
Well, okay.
It's pretty clear law. I think.
Well, the other thing is, I don't know if he denied, the other thing is he didn't deny adopting it. He said, and he gave an explanation.
I know.
Right, but I don't believe that lays the foundation for a prior inconsistent statement. Him saying, "Oh, I did sign this, and this is why I signed it."
Okay.
And then, so.
Well, the statements on the document say every bit of this is true, and I acknowledge every bit of this. And he testified inconsistently to that with regard to the majority of it.
He did, but he never said at the time he didn't acknowledge it to be true.
I think he did. Okay, so to me, I don't know if the entirety of it or just the parts that he denies are admissible, but does it really matter?
It
If,
does.
1, 2, and 14 through 15 come in?
I'd have to really look at it, and this is, the state has not given us a proposed redaction, but
Do you propose to redact that at all?
No, and just as a
Well-
point of clarification, on the first day of direct examination, he specifically said that 1 was not true. He said that on the second day, he came back and said yes, but the first day he said no.
it's interesting that Ms. Love says that, because when she actually was examining him, she misspoke and said that he adopted number 1. So now she's saying he denied it. Yes, I believe that if we're going to admit them, if the state's not willing to redact it, then it should not come in.
All right, so
What is it that they're proposing that we redact, Your Honor?
the parts that he didn't testify inconsistently with.
So I believe that the document as a whole serves to rebut it's a contradiction. The document as a whole is a contradiction, impeachment by contradiction. It serves the other the three things that he said he admitted, 10, 11, and 12, I'm sorry, 5, 10, 11, 12, 14, and 15, provide context to the types of admissions that he was willing to make. It provides context.
All right, well, didn't they watch a video
Not
of you
with-
reading out
Not
just the parts that he said were inconsistent?
Yes, just the parts that he said were inconsistent. And I believe that the document as a whole is evidence, powerful evidence of what the document contains, of the statements that he makes in the documents. I think it's evidence. The fact that he signed, the fact that the document exists, the fact that they can see what it is that he was looking at, and compare it with what it is he is saying on the stand, allows them to further assess his credibility. It corroborates what they saw. It corroborates his understanding of what it is that he was signing.
All right, if we're talking about is it an exception that permits its admission, it being corroborative doesn't get you over that line. So yes, sir. Yeah. Now it may be that what you mean to say is that the entirety of the document needs to come in because that's the only way they can understand it. Is that what you're saying?
Yes, I'm sorry for not doing it as well as the court did. When I say context, yes, it is the only way that the jury can fully understand the document and what was before Mr. Sledge at the time that he signed it.
The state's stance is that the jurors can't possibly understand one factual acknowledgement about a video, for instance, without being provided another factual acknowledgement about gas stations on Cleveland Avenue. That acknowledgement about gas stations on Cleveland Avenue just sheds light on this acknowledgement about the video that allows the jurors to understand that. That's ridiculous.
You had him admit on the stand the factual assertions that he still agreed with, right?
I had him not read from the document.
Did the jury in any way hear the factual acknowledgements that he still acknowledged?
I believe that the
You
answer
know
is
the
in
answer.
some form or fashion they did. For instance,
hang on just a second, Ms. Love.
Oh.
And you said it, and I think the Honorable Attorney Sharp just said it. My memory, and according to my notes, the entire, from the swearing in of Mr. Sledge, then it skipped. And then the entirety of his acknowledgments, whether he admitted it or did not admit it, was read over my objection on a video audio from Crime and Law, or Law and Crime. And now we're doing it again. That's in evidence. So I'm objecting to it. It's already there. And the state at one time told you that they needed that evidence in because it shows demeanor and he had an opportunity to sit next to his lawyer, and that there was no one else in the courtroom, and Mr. Williams and I and the others weren't there to intimidate him or whatever their word was. This is just cumulative. He's been impeached. He's been thoroughly impeached. So I'm objecting to 444 at all.
and at the appropriate time, I'd like to respond.
The answer to your question is yes. It has been acknowledged.
So your recollection is that on the video, every factual acknowledgement was read?
Yes, that is, if I'm
wrong, please correct me. I'm not trying to be wrong.
That's according to my notes. There was nothing redacted. It went right from the acknowledgements, whether he agreed or disagreed. It was read by Miss Love.
All right, Ms. Love, I know you sent us an email at some point that said, here's what I intend to play,
Respectfully, Mr. Steele is incorrect.
right?
We did.
Okay, so hang on. And was sent Friday, September 6th at 7:45 a.m. And then, yeah, I think that's the right date.
And what
Then maybe again to me at 9:54 a.m.
right. Would the court like that we put it on the screen or just reference the portions that we were taking out?
No. Oh, yeah, no, you didn't play the ones that he said were true. You only played the ones that he said were false.
Right. I know. Yes, Your Honor.
Okay. Okay, so.
And when the court feels it appropriate, I just had a couple of more words to say in response to Mr. Shart's response about 444 and impeachment by contradiction and the amount of time spent on it.
All right, I'm not concerned with the amount of time spent on it.
Okay. then not that, but-
So the ones that are prior inconsistent statements are the ones that he said were false. So if you're arguing that the entirety of the document should come in, what's your basis? Your basis for that is it's the only way for the state to, the jury to understand what he was willing to admit to and what he wasn't later on. What's your argument as to why it should all come in?
So, Your Honor, reading from Morgan versus Morgan versus Covington, 648 F 3rd 172 Third Circuit is a 2011 case. The doctrine of, and this is quoted, this is cited from there. The doctrine of impeachment by contradiction serves as a means of policing a witness's obligation to speak the truth in response to proper questions and permits courts to admit extrinsic evidence that specific testimony is false, of course, because other evidence contradicts it. Other inadmissible evidence is admissible as rebuttal evidence where counsel opens the door to such evidence on direct or cross-examination. The doctrine of curative admissibility relates strongly to impeachment by contradiction. I won't get all into all of that, but when on cross-examination, Judge.
Appreciate it. All right, I'm going to give you your
Would you get that?
documents back.
Thank you. Ms. Hilton's coming.
None of these are yeah, okay. Thank you. Sorry to interrupt. Good.
Yes, Your Honor. So we're not just talking about, if we were only talking about inconsistent statements, then that would limit us to a portion of it. But here on cross-examination, the entirety of the cross-examination was intended to present to the jury the impression that the statement itself was not knowingly or willingly or voluntarily agreed to. And in fact, even though the court sustained the objection to the question, I believe Mr. Sharp said it, or I'm sorry, forgive me, Mr. Sharp, Mr. Weinstein said it when he said, when the state put these words in your client's mouth. So the point of it is, when on cross-examination, whether it's effective or not, when the effort is and the witness has allowed it to happen, that an entire statement is essentially sort of undermined. You say you didn't understand it, you lied because your mother was not well and you wanted to get out of jail. The validity of the statement itself is now, it's impeached. It's almost like you're impeaching the statement itself. You're saying that the statement isn't valid. And so in as much as the statement as a whole does allow the jury to understand, it does place the few admissions he makes in context. We'd ask that it be admitted as not just a prior inconsistent statement, but as impeachment by contradiction.
Your Honor, there's no contradiction. He said that the state presented me a form that they wrote on their letterhead and asked me to initial it, and I did. And that's exactly what the form is. It's a form that they wrote on their letterhead that they asked him to initial, and he did. So there's no contradiction. The document doesn't contradict anything he testified to. Now, there needs to be a hearsay exception. And the reality is, if they're arguing that things are prior inconsistent statements, they've already been played in the video and we've already heard it. And if they're arguing things aren't inconsistent, then they shouldn't be played. There's no reason for the hearsay to come in. So even if I granted to them that it's a prior inconsistent statement, we've just established that we played a video with all of that being read, the jury's watched it, and that was covered. So at this point, that form for any hearsay exception that it would fall under, that's already been covered by the video.
All right, I'm gonna rule on this one that the portions that he disavowed on the stand may come in as extrinsic evidence of the prior inconsistent statement. And we'll deal later with whether they actually go out as continuing witness or not.
And for the record, which ones are those?
So I would think that would be, if everybody has it in front of them. My understanding is he disavowed 3, or at least portions thereof, 3, 4, 5, 6, and these are all under 4, under, factual acknowledgements. 7, 8, 9, and 16. And then every bit of Section 5, the sentencing acknowledgements. He said he didn't understand any of them, even though he initialed saying, I understand fully each of them, as well as the paragraph underneath that.
He also acknowledged on day 1 of my direct, number 1, I wrote it, though he changed that.
Well, if he changed it, then it was no longer inconsistent. I mean, when you were like, all right, here it is in front of you, tell me which ones there you have any type of problem with. He did not say number 1. So I made my ruling. All right, so that's that one. That is, and I don't know whether you're gonna tender 444Y. That would make more sense. You've established that it's the same as 1AS.
I did.
Okay.
When
I'm listening. Yes.
I'm going over just one moment here.
Okay.
Yes, Your Honor, that is, we understand the court's ruling with respect to 444Y.
All right. And I don't think it would come in as, whatever it's called, the rule of completeness, because that would be if one party's introducing it, the other party has the right to do more. And this is all one party over here trying to get it all in. So that doesn't apply. All right. I think now we can move on to the rest of them, which are all sort of, I need a bigger bench. The same thing. Well, I guess what's in 460 is not contained in any of 451 through 456. Is that correct?
Well, 460 is Mr. Wright's email to us.
Back. Okay.
Right. And so 460, and by 460, I do mean the last four pages.
The part where he says, let's not do these ones, or here are the issues with these ones. So do you actually want or need the rest of them in?
Judge, because, so
And if
the answer
so,
is yes. And I
okay,
will-
under what basis?
Okay.
Under what evidentiary rule?
Yes. So as to number one, because Mr. Sledge, on the second day, he agreed and gave testimony about examples of number one. It's not so much that it's an inconsistent statement as it relates to number one, but when Mr. Sledge on cross-examination asserted that he did not have the ability to change things, that we didn't change things for him, showing the way that the recommended changes were presented to the state. What is not said is as important, in our opinion, as what is said.
All right, are we talking right now, I'm sorry, about just that portion of 460 that's Mr. Wright's 8:43 p.m. email?
I should have been clear. Yes, just, and the second part of that is just a duplicate where I asked that copies be made. So we are only talking about Mr. Wright's December 27, 2022, 8:43 p.m. Response to the state. Subject line is Sledge agreement updated. And with Mr. Wright on the stand, I clarified what exhibit came in before that he was responding to, which was 452.
Okay.
And then what exhibit came after that, which I believe was 453, but I'll check my notes to ensure that that's the case. So in as much as number one, he's saying, okay, there's no caveat, there's no, oh, hey, we need this. Okay. So number two, obviously, Mr. Sledge agreed to number two, but there is an additional, they formed about 3 years before Peanut was shot, him offering up that kind of information, Mr. Sledge offering up that kind of information. He is nowhere in there is he asserting it's a record label.
All right, well, nowhere in his factual acknowledgement on number two is it asserted what YSL is. It just says defendant has been a member and or associate of YSL since blank.
Right.
So he wouldn't need to say, and by the way, it's not a gang.
I agree with that. Also, but in number one, where we say what it is, we don't use the word gang. We say something, we use specific language that he's perfectly okay with. And then in number two, he makes no effort to, qualify anything as he did on the stand multiple times.
Okay, well, as we all know, the case law holds that it's actually not illegal to be a member of a criminal street gang. It's only illegal to commit crimes in furtherance of it. Well, to commit crimes, period. And then it makes it a gang
What makes
violation
it a gang is a crime.
commit crimes in furtherance of.
And that's why number one says.
Right, and so, I mean, number one is whatever number one is, but, you know, that number two says, oh, by the way, it was about 3 years before Peanut was shot.
It's that he's offering information, and I'm gonna defer whatever the court's ruling is,
Mhm.
but it's that he's offering additional information. He's
I think
comfortable enough to say.
I think that is okay, I think it was about 3 years beforehand, so it must have been about 2012.
Okay.
Okay, so,
Nu-
3.
Number 3.
Didn't we read that into the record?
We did. We read the response Mr. Wright gave,
Okay.
and I
We
believe
did
we
read that.
read,
We did read it into the record.
if I
Your
make
Honor.
it, I
All right.
believe we read as well the portion of 452, that was number 3, and then the final. I think we read 3 number 3s into the record, just so that the court is hearing what I believe is the full truth. We read not just that, but I asked him to read what he responded to and then how we changed it for him.
We read at least the final version of number 3.
We
many,
did.
Many times.
Oh,
So number 4, back on the email by Mr. Wright.
Okay.
We never read that in, right?
So
I'll
number
remind-
4,
I'll remind
we did
the
not.
court that we approached about number 4. There were obvious problems with number 4 that were inadmissible. We were told to stay away from number 4. The state was told away from number 4, told to stay away from number 4 for obvious reasons. There's all sorts of speculation in there. And now, after being told to stay away from it, and we were told to stay away from it, and we did not address it during cross-examination. Now, after witnesses have testified, the state's seeking to admit a document that has number 4 in it. And it's just,
Yeah,
I mean, I don't
yeah.
know what we're doing.
Okay.
Your Honor, may-
Number
Yeah.
5 is not even relevant, right?
Your Honor, if I may just circle back briefly, as it relates to number 4, there was an objection to it. We followed the court's instruction. We did not ask him about it. And when the issue that I have with number 4 not being addressed here is more importantly, I don't know how an assertion that the witness did not adopt is prejudicial when he is not, he denies it and we change it and we take it out, that he was planning, he had personal knowledge that they were planning. That is powerful because it is a material fact that
He doesn't
denies.
have personal knowledge
That's
that they
ex-
were planning it.
Judge, that's the point that I'm making, that he says, I did not know that. The fact that something that,
Even saying I did not know that is sort of like,
or that's not
it
true.
was true, but I didn't know it.
No, he's saying that's not true. He is
No,
saying.
he's not. He's saying, I don't know. I think maybe XYZ. That is not coming in. That needs to be kept out under 403 if nothing else. And that's really the only thing you wanted in, right? So
I didn't hear you.
is that really the only thing from this that you wanted in?
When you say this, you mean
From this being this part, the 8:43 PM email from Mr. Wright that is
Oh.
included within 460Y.
I didn't even, the language of what he says, I didn't even need to have that in. I mean, I understand why that would be considered, and I understand the court's position there. why it would look like something was pre-planned. The reason that I was asking or seeking to have the assertion in is just to show that he says no to it. We could take out all of number 4 under Mr. Wright's email and just say, no, I don't, just, he denied it.
Well, we can't make it say something. it
No,
doesn't
not
say.
put the word
How
no.
could we
He
do that?
said, Mr. Wright said on the stand
Okay.
that is something that we did not agree to and we took
Okay.
out.
And that's exactly the point. Mr.
Exactly.
Wright said all
All right.
this stuff on the.
We're not going to be admitting 460Y. And that leaves 451 through 456. And those kind of, what would be the theory under which those would come in?
It, Your Honor, provides, it contradicts Mr. Sledge's testimony when I presented him with a prior iteration that there was an objection to it being called a prior iteration. And I asked him to show me things that were different. It contradicts his testimony that he saw prior iterations and was allowed to make changes to the prior iterations. He said on cross, the first time he ever saw that plea agreement, it might have been the first time that he saw.
Well, that was the first time he saw that plea agreement because all of these were prior versions.
And when I asked him, did he see any prior versions? My recollection is that he denied.
I don't remember that. I think he said the back and forth between us and the state was up to my lawyer. I left that to my lawyer. That
And
was
Mr.
his-
Wright clearly testified that he took a version to speak to Mr. Sledge the night before.
And you know, I look back at.
All right. Well, subject to that actually being some kind of and it's so that would be what, impeachment by contradiction?
Yes, it would.
Okay. Well, you can let me know if he actually testified
Your Honor.
in the way that you remember it. Yes.
And I don't think we should have to litigate this again, and I'm going to explain why.
Okay.
The state, under the state's theory, well, I mean, why don't they just do this for every case? They could write out their facts, just send them to a bunch of witnesses. Witness doesn't need to initial them at all. And then they take the stand, and then we just start bringing in all copies of documents that they wrote and sent to witnesses that witnesses looked at. I mean, it's false facts here. It's facts that haven't been adopted on these documents. There's inadmissible statements on these documents. It's a mess. And we didn't create this. We didn't tell the state to do it this way. We didn't tell the state to write their documents and then send them to an attorney, write the statements and send them to an attorney and see what the co-defendant says or the witness says. We didn't tell them to do it this way. They created this problem.
I understand. You can get back to me if you can find some kind of testimony that you think lets you get this in. Right now, they are excluded.
Yes, Your Honor. Thank you. And I will look for that.
Yes.
I can't say with certainty, but I'm just going to ask if there is also a case which I, in my mind, the recesses of it, believe that it may address specifically like
Okay, well.
iterations.
Sure.
Okay, thanks.
Even if Mr. Sledge did say there were never any other versions, which I don't think he said, you've disproved that by presenting the testimony of Mr. Wright. So I think given the number of 403 concerns there are with 451 through 456, I'm going to just stand on my ruling excluding them.
Your Honor, with respect to the 403 concerns that were raised, given that 403 addresses matters that are substantially more prejudicial than probative, and given the extent of the cross-examination and the efforts to undermine the willingness or knowingness of Mr. Sledge's statements, essentially even in the arguments that are made, it's essentially the argument is that this isn't a statement that Mr. Sledge made. Showing that Mr. Sledge, showing a prior statement, contradicting that testimony.
That's what 444Y is. And that's it.
That's the ultimate one that he signed. But showing, yes, it is. It
I
is.
know.
Showing that he was untruthful and letting the jury decide, why are you telling stories about that? About seeing a prior version, we believe is strong evidence that allows them to judge his credibility, why he's saying what he's saying, any bias he may or may not have, and help them to determine the truth of which statement they should believe. So we would ask that the court, I don't know, revive its prior ruling, revive the ruling that the court made.
Denied. Let's move on. All right, what were y'all tasked with over the lunch period?
Your Honor, we reviewed the proposed segments of those videos that showed Mr. Beebe and Mr. Eppinger referring to and they weren't referring to it, but it's clearly involving the armed robbery that they're charged with that's listed as an overt act. I can say on behalf of myself and Mr. Steele, we have objections. I think Mr. Steele was going to articulate them
All right.
to those segments.
Okay, I think it would probably help for me to be able to see what those are, but before we do that, 463Y, were you intending to tender that at all? I don't know if that was one that you had included that we said we'll circle back or not. That was the one that was just his sentence that showed that he got the sentence on the second count too.
No, that was just to refresh his
All right,
memory.
thank you. All right, can you cue up the portions of that video, please? Hmm. Together that, just the portions of that guilty plea. So if we're going to be just showing portions of various videos and things, if y'all could do that for those as well, that moved things along much more quickly.
Thank you, Judge. We will after we
Great.
work it out.
Decide. Okay. Thank you.
The first portion of this video, it ends in 2624. In the video, it's the Durante Beebe, and it'll be Christian Eppinger. This is after the armed robbery that both are alleged to have committed. Mr. Beebe has recently or did plead to the charges in this indictment regarding this armed robbery.
All right. So I'm sorry, timing wise, this is shortly after the robbery or shortly after?
Shortly after the robbery.
Okay.
And we're going to begin the first portion at 1:12. And it's about 3 seconds around from 1:12 to 1:15.
What y'all going on, man? What's up, Slam?
And you're right, as you see, or if you see there, when Christian Eppinger gets onto the call, he throws up what we have alleged is the YSL sign, and then Durante do it back towards him.
Okay.
The next portion around is 2 minutes and 45 seconds to 2 minutes and 52 seconds.
Anybody here? I'm out there. All right, Slap me.
Can you get rid of that box by chance?
Yes.
I don't know why that does that, but.
And so, Your Honor, if I need to play back, I will, but when they're ending the call, they both say slat, which is a terminology that we are alleging that YSL members
Right.
use. And then the last portion is 356, 408.
I mean, but they hit them up. Yo, my artist, man, they give me, I done built me a business up.
And it ends there. Just a few things. The clothing that he is wearing around, I believe this is OTS on the slime clothing that he is wearing. This is also his public page. And so immediately after this call, he then points a gun at and towards the camera. Again, going towards the state's theory that members of YSL operate with violence and using guns to show their threat, their notoriety, and given everything that has happened in the video, those relevant portions. Those are, for this video, the 3 portions we see.
Ms. Hilton, excuse me.
Can you not hear?
I didn't quite follow the first thing she said. Something about what was on the clothing.
We believe that this is clothing that we've seen on other YSL members. It's either OTS or on the slime clothing. We've seen, and I think we have a few other posts, Your Honor, with them wearing similar type of clothing, but it has either YSL or related terminology on the clothing.
All right. And on what piece of clothing is that?
On his, I believe, the headpiece as well as the shorts.
All
Your
right,
Honor.
can you show me that last portion again?
Yes, Your Honor. And I started a little.
So, oh, the headpiece and the shorts.
They ain't got no involvement, but they hit them up. Yo, my artist made minimum. They give me, I done built me a business up.
And what does he say?
Built me a business up.
I heard that part. What does he say before then? Is this just to show the clothing?
No, the clothing and the pointing of the gun.
And pointing at the gun and saying,
They hit them up. Yo, my artist made minimum. They give me, I done built me a business up.
I think he's rapping a lyric to a song, but he says he hits them up, and I'll have to go back and look at the other portion of the language.
Your Honor, procedurally, are you wanting us to argue these one at a time?
I
Or
think, yeah, that'll be this set, not like, well, not necessarily one portion at a time, but like this will be, I'll hear the argument as to this. So I guess there's the beginning where they're throwing signs, the end where they're signing off with the language, and then the middle, the end of their call, and then the end of his post where he is wearing particular clothing, pointing a gun and saying something indiscernible other than that he's going to build a business up. But maybe you can let me know what he's saying. But if what he's saying doesn't matter, then
I have,
okay. All right.
I have reason to believe that he's singing a popular
Okay.
line from a song that
All right.
is not involve anyone in this room.
Okay. So is this line of, what's the line of clothing?
So
Is it like a line of clothing you can buy in stores?
I don't know if you can buy it in stores. We believe that there's one member of YSL, Miles Farley, who is purportedly a clothing designer. He creates
Okay.
some of the
So-
clothing.
That is
Okay.
I don't know if this is that,
That's
but
not his clothing line.
oh, well, but the clothing says, and I have another picture because I believe this is from all the same line.
Okay, but I mean, if this is something he's wearing and you want it in to show that he's a gang member.
And the clothing says, and I want to back up, we believe it says slat on the clothing, on the shorts. And I'm looking at another act that we have, Act 143, with him and Christian Eppinger, and Christian Eppinger wearing a jacket similar to the pants and the hat set that he's wearing in this particular video.
And when is this from?
This video is around October of after October 10th of 2021. The armed robbery takes place in October of 2021.
All right, and tell me why y'all are offering this.
Your Honor, so with the first two portions is to show that both Mr. Eppinger and Mr. Beebe, again, right after the robbery, are in communication with each other, showing their association with YSL by one, using the gang symbols, and two, using terminology in which members of YSL uses. And then the last portion of the video, which is when he places the gun inside of the video, Your Honor. Again, this is a public posting of Mr. Beebe. And it shows, again, that members of YSL uses this gun for no reason comes into this video at the end. There's nothing, I don't know what the purpose of actually flashing a gun is, but to show that he, as a member of YSL, has handguns, uses handguns, especially coming after an armed robbery, which we allege.
All right,
he
and the
uses-
armed robbery was what, like October 12th or something
October
like
12th of
that? And then when
2021.
is this video posted?
I just need to pull up the Instagram, Your Honor, of when this exactly video was posted.
And can I ask the state another question while they're looking into that? It's being, and I'm sincerely asking, it's being stated that this is a public posting. And I'm wondering was it a public posting or was this something retrieved off of his cell phone? Because those are two different things.
It was not retrieved off of his cell phone. We got an Instagram return for Mr. Beebe.
So yes.
So
these
was
are
this on his
public posts.
Instagram page? Was this a story that disappeared after 10 seconds? I'd need a little bit more context about what exactly this video is and where it came from and how it was presented to the public.
It came from his Instagram return. His page, we do not believe, was a private page. And the Instagram video was of him. It's a Instagram call that he makes with Eppinger, so it has to be public because Eppinger knew to log into the call when that's how he gets onto the call.
So is it public between the two of them?
No,
Forgive me, I'm not.
no, I believe it's
Instagram
public to
familiar.
Instagram because
To his private page? Because you said it was a public post on a public page, but then you said it was from his private page.
no, it's his personal page.
Oh,
But
okay.
a public.
You don't mean it's private. You just
No,
mean it was his page.
personal page.
Your
Okay,
Honor,
but it's a
people-
public page.
People that are younger than me that are helping me here are telling me that this is not something, like if I wanted to check out what Mr. Beebe was doing on Instagram, it's not something that I could find publicly. This was a call.
If you followed it, like if, I know a lot of people have lots and lots and lots of followers, like thousands and millions. Would any follower be able to see this? I'm just trusting the youth in the room now to. I can Google it. All right, let's assume for now that it's a public page and we can circle back
My
on that.
understanding is once the call, and this is my confusion why I'm asking the state. Okay, I'm using call, but
Once
it's not
the-
technically a call. Okay, but once the interaction is done, it is not saved. This is what my understanding is. It's not saved on his page. So I would not be able to say, hey, for instance, if I said,
Could you watch it while it's going on if it's being posted to the page?
if you were, I think it depends if you were invited.
If you're a follower. I mean,
Yes, so.
whomever.
With Instagram, if they are on a Instagram story, oftentimes
Mhm.
the other person watching your story could get onto the call if you accept it.
All right. Can they watch it regardless?
Yes, can they, who does that?
I don't know. Somebody other than the two people communicating
Yes, other people can watch.
can watch it.
Are you saying can watch it if they're given permission to watch it, or are you saying they can just watch it? Because our
If they're
understanding-
followers or if it's a public post.
They can watch, I can log on, I was friends with not a friend, if he has a public page and he's in his Instagram story, he's talking to someone, I can log in and watch.
And then there's clearly something he does even after the communication is over that he's showing in the post.
Right, and he can, and then the other person, Mr. Evinger, can come out of the call. He can
All right, and does it disappear or does it stay up
I
until you
believe
take it down?
disappears. I believe it disappears.
Okay, so it's up for 24 hours. And do we know whether this is an Instagram story?
I'm going to confirm, I believe.
Okay, well, we'll assume for now that it's a public Instagram story that's up for 24 hours.
And I'll add one other thing, and I can't say this with certainty. On one of these calls, or whatever they're called, one of these interactions between him and Eppinger, it was determined that no one was in the room. So I don't think that there's the room, meaning watching. So
The virtual
I
room?
don't believe that.
Well, I'm not sure that matters.
Oh,
If you're
well.
posting it to be consumed publicly, if there is somebody watching.
Okay, well, I think you can tell if there's people watching or not, and I think it was this call, but I don't want to swear to it.
All
But I have no evidence that anyone was actually watching, other
Okay.
than him and Eppinger.
So do you know when the post was made? Have y'all been able?
I misspoke, Your Honor. The posting was 2 days before the so on October 10th is when the posting, according to the Instagram video, was
Okay.
taken.
All right, but close in time.
So it was close. So it was 2 days before showing
All right.
these two individuals.
Okay, I think that the first two portions are relevant and not excludable under 403. The third one, unless you can get me a whole lot more to explain why that clothing makes any difference at all. The fact that he's holding a gun when nobody can, when all he's doing is singing, doesn't show anything.
You're right. He is representing, we believe, with the clothing on YSL prior to an armed robbery that he commits with.
Okay, I understand you believe that, but until you can get me some basis to believe that.
To believe that the clothing is.
That the
right?
clothing, yes, it makes
Yes.
any difference whatsoever.
So, Your Honor,
So.
with respect to the case law that has come out after Rodriguez and all in the furtherance of a gang.
Uh-huh.
So some of the things that courts have named as evidence of furtherance of it being done in furtherance of the gang
Mhm.
is whether or not the person is wearing items of clothing, articles of clothing that have or bear the gang name, if they say the name, if they do things that represent the gang in close proximity to the time of the crime.
I understand that.
And with the fact that he is pointing the gun at the camera and saying whatever he's saying, we would, our analogy, we draw the analogy that in pointing that gun at the camera, if, as Ms. Hilton is looking, we find sufficient to the court's satisfaction that he is wearing YSL clothing, in the same sense, he's representing YSL as he's pointing that gun at the camera, making the statements, whatever they are, singing or otherwise. And in doing so, he is making a public assertion about YSL's willingness to perform violence
Sure.
or to, you know.
All right, y'all get back to me on the clothing.
I'm
All
ready
right,
for
well,
the
Okay.
clothing.
I
So
think-
I'm going to show a portion of the video.
Your Honor, I think I'm probably stating the obvious, but that's not when the armed robbery happened. So.
Yeah, it sounds like it was
so-
2 days before.
Yeah, so I don't know about what Ms. Love just said, this has nothing to do with showing that the armed robbery was somehow gang related. Even if he's wearing that clothing, but Your Honor, regarding the clothing, again, I agree with Your Honor about the ruling and we'll look at the clothing, but the gun, I don't like, the thing about clothing is we can get a screenshot and see what someone's wearing. I don't know why we have him rapping and pointing a gun, because that is just
What
a
lots
man.
of people unfortunately do these days.
Right.
Your Honor.
Yes.
And further, what clothing is this? Because Ms. Hilton, first she said she thought it was one clothing, then it might have been somebody else's clothing. So can you please tell us what clothing line is this?
I can't tell you the clothing line. I can just tell you that the clothing has slat on it. And if we look at his shorts, and this is at timestamp 3:43. I'm using this timestamp, and then I also now want to show the court Act 143 with someone wearing the same similar clothing, and where it's clearly that it says slats on the clothing, which is terminology used by YSL. So.
Okay, you're showing us where it says this on this clothing.
So on this clothing with the black base, the blue lettering says slats. And then there's also some red items, but we know that the blue lettering says slats. And I know this, or we believe it is this because just need to pull up.
Do you have him wearing other gang paraphernalia at other times?
That's what I'm
All
pulling up
right,
now.
then that's gonna be sufficient.
So at the 143, Your Honor, which is, we believe on September 29th, 2021, so about 2 weeks before the
Mhm.
video, Mr. Eppinger, who he's in the video with, is wearing the similar clothing, the slats. He just has the jacket version on.
Okay.
And then BB is wearing the OTS, which says only the slimes. I don't know who created it, but it's slime clothing or slat or YSL affiliated clothing, Your Honor.
And who is that? Is that?
So that's the same. So the person in the jumpsuit is Mr. Durante Beebe. This is the person who had the gun in the video.
Mhm.
Next to him is Mr. Eppinger, who was the person who joined.
Okay,
the
so you
video.
have both of them a couple of weeks before wearing what y'all allege to be gang clothing.
Yes, Your Honor.
All right, that's enough. You can have those two portions that are the beginning and the end of his call, and we're not gonna do the third portion.
Okay, thank you, Your Honor.
Yes.
I want to, if you rule definitively, I want to just put my objection on the record. These are out-of-court statements. Mr. Beebe and Mr. Eppinger are not here.
Mm-hmm.
So it cannot be, the way I understand the law, admission by a party opponent because they're not on trial with us.
Right.
And therefore, it has to come under some sort of co-conspirator hearsay exception. And I don't know how this furthers a conspiracy to say, and I believe these are quotes, what's going on in the first 112 to 115, Your Honor, and then what's up, slat. I don't know how that furthers the conspiracy, so I'm objecting to the verbal. In addition, I asked the court, there are a tremendous amount. There was a contest on the internet who can say slat with a song so many times. I tried to put that in evidence, and Your Honorable Court sustained the state's objection and said, who cares? It's a popular thing that is being said now, and who cares that people are on the internet saying that? The state just said that slat is important because that's what YSL members use. I want to show that everybody uses it. And slat was a popular term before 2012 when this supposed gang formed. You will learn if you let it
Did
in.
somebody already establish that?
I
I know
tried
you
to.
established it with regard to like some of those other sayings.
Yes, Mr. Trantavia Stevens stated that when he was younger, it was made popular by a rapper, an artist named
Right.
Lil Wayne.
Okay.
So I was stopped from doing it. So I'm objecting. I understand. I'm not trying to belabor this, but I'm objecting to all the verbal statements. And then I just think it's nothing here to me furthers the conspiracy. And
All
that's
right,
the only
well,
way to do it.
Thank you. All right, so that's that issue. Oops.
The next video. It ends for the purposes of the record in 3396. And I'm going to find the date, Your Honor. This is after the robbery. And we'll play from 10 seconds to 2 minutes and 52 seconds.
Do you know how far after the robbery?
That's the date we're looking up now. Yes, sir. This is on 10/13/2021, so one day after.
One
the
day
offer.
after. Okay.
All in the club throwing gun signs. All in the club throwing gun signs. Got all the fuck going on, man. Shit, why so?
Okay.
Few things, although he's in the bed saying he's in the club throwing gang signs, he threw up the YSL sign in this video. He threw up, we believe to be the little B blood sign in the video. More importantly, I freeze frame on the chain. This is the chain that was stolen from the victim 2 days prior to, or a day, excuse me, prior to the this video being posted. He's also wearing, you can see his headpiece or the hat or the mask that he has on his head is also another mask that says "Keep America Slime Again," and then he says "This shit YSL" at the end. So,
okay,
for those reasons, we believe that is relevant.
Anybody want to argue against that?
Sure.
And just like the first one, I'm not conceding that this is for publication for the public, and I haven't heard how the state is going to lay that type of evidence before the court. And I don't have that evidence, so I can't tell you that it was for publication. I
So
can't
it's a
tell you
live-
private.
Okay, we'll circle back on that.
Okay.
I don't know how the state's going to prove that that is the chain that was stolen from Mr. Smith.
I bet it looks like a pretty distinctive chain. Are you going to have
Wrapped
somebody
around.
to
Yes,
identify that as the proceeds of the robbery?
the victim goes by the rap name Trap Commander, and that's what is said on the chain that is stolen. And we intend to call that individual.
Okay.
And then I don't believe that this, depending upon if it's public or not, I don't believe that this furthers a conspiracy, which it has to, the way I understand it, for his verbal statements.
All right. Can you respond to that?
Yes, Your Honor. So in looking at the Instagram return, we know that this video is from the archived live videos.
Okay.
Instagram does not disclose, at least on our immediate review, whether it's a public page, but we know it's a live video. I imagine he is broadcasting it out to someone because it's a live video. He's not broadcasting it to himself. And so a live video is what we discussed earlier. He gets on Instagram and anyone who is following him can literally open up his icon and see that he's doing a live video.
And if you haven't yet, are you going to present somebody to explain to those of us who are not 20
Yes.
that all of this is true?
Yes, Your Honor. We will
Okay.
have someone explain Instagram for Instagram. And because he is posting a day after the armed robbery, the boldness of stealing the person's chain and with YSL paraphernalia on and saying YSL. For those reasons, we do believe it's in furtherance of the ultimate YSL enterprise conspiracy.
All right. I'm going to rule that admissible. Yes, when I rule it admissible, I have done the 403 analysis and found that it is not excludable under 403. Nothing in there is substantially more prejudicial than probative.
The next item, number 16, and that's going to be from 53 seconds to 2 minutes and 50. And for the purposes, we'll identify it as the last four digits, 5860.
This is
And this
also
is
Instagram.
It's also an Instagram video.
Live feed.
A live feed as well. And this is on October 14th, 2021.
Okay, so 2 days afterwards.
Yes.
Okay.
52 seconds.
What? What they do? Well, hold on now. Oh, lock Slate face up. They locked Slate face up. They did. Yeah. Damn, why everybody did? Yeah, they wound up. You Slate face, man. He said, what? He said, so where you at? You still on the way up there? Yeah, we on the way to the room. We on the way to the room right now. Oh. All right, I'm gonna call you. Yeah, all that motherfuckers playing. Cigarette, yeah. Flat theater, man. Huh? Hey, I'm at the studio. You at bullshit? Yeah, I'm gonna lock in right quick. About 4 or 5 hours. You'll be back by the time you're here. All right. Yeah. Hey, wait. Oh, yeah, slap fit, no rat fit. No kids. Think somebody add me, please. What that is? Where you from? Boy, how the I don't think get out of this shit. Hit the phone.
And we can stop it at 2:47, Your Honor. So a few things that occur in this video is Mr. BB is on his way somewhere, and Mr. Eppinger joins the call again or joins the video again. You hear him say, as he's holding up the chain that they just stole a day before, says slap business, and then later again they say slap business, no rat business, Your Honor, and believe that testimony will come out during this portion that Darius Smith had went to the police, after he had gotten robbed. I believe there is some information that he was being threatened after he went to the police.
Okay.
After he went to the police, Your Honor. Furthermore, also in this video, you see another co-conspirator, Miles Farley. When they pan the camera to the individual who's in the front, he appears to be sleeping. That is another co-conspirator in this case, which is Miles Farley. So for those reasons, and you see them also in this video putting up the YSL sign as well, that for those purposes, this is relevant to show association, to show the furtherance of the enterprise, especially even after the armed robbery.
All right.
May I, Your Honor?
Yes.
I am going to wage the same objections, that it does not further the hearsay objection to the conspiracy. But if your court is consistent, then what I'd like you to do is please wrestle with the idea that the one before 3396, showing the court said that's a specific pendant, and therefore it's relevant, and the armed robbery occurred the day before. This is the following day, so 2 days after it. This has the same pendant showing, so I would argue that under 403, at some point, it's cumulative. So those are my arguments.
All right. So I think, yes, sir.
Yes, Your Honor. I have a question. As a condition preceded to the admission of this particular piece of evidence, public or private is a condition in terms of the social media, whether or not the platform was public, correct? Is that what I'm understanding? It's a question.
So you said this was another live feed?
Yes, this is also for archived live videos.
So if they are downloading that information or those documents from a live feed, how do they know at the time that it was public? That's what I'm trying to understand. I want to make
Well,
sure.
and honestly, you may need to have somebody come give a proffer on all of that. I mean, I hear you saying your understanding is that it would only be archived if it was the live feed, and that live feeds stay up for 24 hours. And I think that anybody who wanted to log on to that page could see it, or at least anybody who was a follower could see it.
Definitely anyone who's a follower could see
Okay.
it. And I think that's the distinction. Anyone who's a follower of the person could see it. Whether or not someone who's not a follower could see it would determine whether or not it was a public or private. I don't know if that, to me, that goes to weight, not admissibility of the evidence coming in, whether or not it was a private or public page. But what we know is a live video. Other individuals can see that, whoever may follow him, or if it's a public page, people who don't follow him can see it. But other people besides himself could view the video.
So, I mean, this one it's a communication between and amongst several co-defendants and alleged co-conspirators. Given all that she set forth as the different things that were significant, I don't think it's just cumulative of him himself sitting there with the chain. This is him talking to his
co-defendant,
co-perpetrator
yes,
of the robbery, and talking about slat business and rat business. So it's not simply cumulative. It adds a whole lot more. And honestly, whether this one is
Right.
public or not,
Okay.
it's them talking in furtherance of the conspiracy. So for this particular one, it wouldn't be significant to the ruling, whether it's public. For that first one, it seemed to be, I mean, for one thing that she was saying, that was one of the reasons why, but yeah, not really for this one.
And for the court, I'm being told that whenever the court does consider public or private in terms of whether or not it's a condition precedent, that there should be some comments or icons demonstrating how many viewers are present, common.
Okay. So I don't think how many viewers actually see it is significant to the fact that you might be putting it out there to be seen. Or you're putting it out there where it could be seen.
And comments and viewers count are key, you know, to determine or in allowing. I'm just trying to read the writing.
That's more what it's like. Would you older people please stop talking about this?
But Your Honor, the reason why Attorney Matthews is bringing up comments and things of that nature is because when it is public, even just public, meaning that your own followers can see it, you would tend to see commentary from even your own followers.
Okay.
So I just don't think that the state has proven that the videos, at least the videos that you're considering, whether it's public or private, even your own followers being able to see it, I just don't think they provided any evidence of that.
All right. Well, I don't think it really matters for this one. So I find this one to be admissible.
Your Honor,
Yes.
before, this has nothing to do with the court's ruling. I'm not trying to relitigate anything, but
Mhm.
while Ms. Hilton was speaking, she mentioned Mr. Darius Smith and their possible threats or something of that nature. I don't know of anything that I've been told or provided in discovery that provides any information about that. So to the extent that the state's ever going to want to get into anything like that, I would expect to be given some information.
Some production of something.
Yes.
Are y'all planning to get into that?
I believe it's already, and we'll double check. I believe it's something that's already in discovery that after this, whether it was his interview, whether it was Mr. Smith's interview, that he talked about receiving threats because he went to the police. And so I'll
All
find
right. We'll
specifically.
just make sure that they've got that.
Okay, so there's no video of any threats or
No,
anything?
no.
Okay.
Okay, it's just that he says during the course of his interview with police when he was reporting the crime. Yes. Okay. And y'all are familiar with that?
I'd have to check too.
Okay,
I just
that's
didn't
fine.
remember seeing any
Okay.
videos or.
Yes.
I know you just said that the last one, which is 5860, has more, so it's not cumulative of the
Mhm.
previous one, 3396, but wouldn't 3396 then
Then
be?
be cumulative.
Yeah, that's what I was arguing earlier, because you said that it's coming in because it's showing the unique trap commanders, what I believe it says on the pendant. I think it says trap
Yeah,
commander.
no, I just thought that when you, that comment was when you said, how do we know it's his necklace? I was
Sure.
saying that looks like a pretty unique necklace.
But wouldn't, I mean, at some point, is it I know it's short, but isn't it cumulative of the next day?
You know, that is much more to me, him really kind of flaunting the necklace that had just been stolen a day before, flashing money, throwing gang signs, saying, if he said, I heard him say this shit, YSL. I think that is somewhat different than what we see in that 5860 video.
Your Honor, after all of the
The videos, okay.
Yes, after all of that, I just wanted to make a general, ask the court's instruction on a general matter about
Okay.
cumulative nature, but I'll let the court go through all of this. I just didn't want to.
Well, what do you want to know?
Generally, what I'm hearing is that whenever a video, a picture of something is shown that's slightly similar in nature to something else, there's been the cumulative of the 403
Mhm.
objection. And the court knows and everyone does that there are 65 counts in this indictment and 8 defendants currently on trial. And to the extent that some of the evidence in the court has been essentially ruling along these lines, but I just want to say that to the extent that there are efforts by the state to put in multiple showings of a defendant doing or other defendants or co-conspirators doing things that may appear similar on different times or at different days, this is meant to rebut this continued assertion by counsels for 8 defendants on trial that this is a record label and nothing more. So I just wanted to put out there regarding the cumulative and the 403 objection that we constantly get when there's some similar, and the court's ruled the way, I believe that is proper, but I did want to respond to that objection that is constantly being made. Thank you, Judge.
Well, to me, cumulative isn't whether there's some reason to put it in to rebut something or not. It's do 7 or 8 different pieces of evidence show the same thing? Then after like probably 2 or 3, 4 through 8 become cumulative. So you're not necessarily limited to, oh, I can only show this one way with one piece of evidence, but you don't need to show the same thing 8 different ways.
Well, Your Honor.
Yes.
Ms. Love's argument may remain the same, but it's not 8 defendants, it's 6. It's okay.
You're right.
Right,
I suspect your argument would remain the same.
I found where we were referencing at least some indication that maybe the victim in the armed robbery was being threatened.
Okay.
It's going to be in Discovery 7. And within Discovery 7, the last police report, it's the first paragraph from May 18, 2022. And then the actual text messages that is referenced in that particular portion of the police report is also found in that same folder in the digital evidence folder.
Okay.
You're welcome.
All right, when do you think we all can circle back on the evidence that y'all were going to get together on with regard to Mr. Ryan?
Mr. Boston, right before the court came out, we were trying to figure out a time. So we'll talk some more after lunch. I mean, after lunch, at the end of the day, just to try to solidify a time within the next couple of
I'm
days.
just not sure we're going to have a non-jury day before y'all might get to that. I mean, we might, but. Okay. So I have some notations on, if we go back to, I guess it must have been on this wiretap, because that's what we've been going through.
Your Honor, you did ask the state to look at least before we get to Mr. Harvey's motion, you had notes on 2 of the recordings.
Okay.
I believe it was what was identified as 513.
Yes.
And /523,
Right.
and then 1109 and 1124. I'll start with the easier one, Your Honor. 1109, 1124, the state does not intend to use.
That does make that easy.
And then I'm not sure if the court just wanted for 513 to 523, the relevant portions of that call.
Hang on. So on that one, It was the part, yeah, the flipping the car and laughing part.
So when I listen to a trial, I don't know if I hear flipping the car, but there is some conversation that starts at about 35 seconds into the call, in which, to set the stage, this call is at about 9:45 p.m. on March 16th. And so this is about 9. The home or the house at 2830 Waters Road just got shot up earlier, late the night before, earlier in that day. And Mr. Garlington is speaking to someone that we believe to be the Waskin Wright, who is a member of 30 Deep. And when they're on the call, they first talk about different types of weed.
Yeah, I said that part then.
And after that, Demekion begins to tell Dewaskin about the drive-by shooting. And he tells them that 12 had us, they shot up Big Nick's spot, which is the home where they are. And we thought that they were going to come back through, meaning that they thought that the ops were going to come back through, that they sprayed through the house, that they were all in the living room, and they're surprised that no one got hit. And Dewaskin asks, well, essentially, why do you think it happened? And Mr. Garlington says, one of their little partners just got shot or just got killed in Mechanicsville, which would have happened on March 14th, 2 days prior. Then at some point in time, a little later within that call, Mr. Wright says, do y'all have a drop on them in words? And Demekion responds, I would need to play it again, what exactly his language was after response to that. And that portion is from 0:35 to 1:40, and then from 1:48 to 2:31. There's a small 8 seconds in there that we wouldn't need to play, but those are the two we believe relevant portions. Again, they're talking about the opposition first shooting up the place and then being asked by a 30 Deep member who we allege they have alliances with, YSL, that some members who were formerly 30 Deep are YSL, and then they still have an alliance with 30 Deep. He then asked, do you have a drop on them? Meaning, are y'all going to retaliate is what we would think that they say. And those are the portions that we believe are relevant.
And those are the only portions of that.
Yeah, the call is only 2 minutes and 30 seconds. So it's really the entirety of the call, except for that 8 seconds that is between 40 and 48. Yes, sir.
Yes.
There's a portion, I believe it's the same call. So I have it as call 513. Mr. Shark gave me that number.
Yeah.
That it says something to the effect, and I was going to object. It says something about McMiller's funeral is going to be private, and his mother doesn't want Thug there or his money. And I don't see how that should come in. That would be a hearsay statement. I don't see how that furthers a conspiracy. If it's not on that call, then I have the wrong number. I have 513.
It's not that call. No. Well, let me make sure.
Well,
hold on.
I think it is.
No, I'm sorry.
Well, it may not be. I don't know.
So there's remember, there's a page number and a reference number.
Right.
I'm with Mr. Steele. I have 513, and I think we're going by the call reference number.
On the sheet.
So the call reference number for 513 is the call that I'm just speaking of, which is on March 16th.
They came through and they were going to come back.
Yes.
Getting ready to
I have
write
the
them
same
up.
date as well. You're on 5/3/16.
What time on March?
So the call
9:41.
9:41. But we can listen to the call, but I just listened to it and I don't hear
We're not
anything
going to
about
play it. If it's not an issue, there's nothing to discuss. But if it is an issue, I wanted to raise.
Okay, because part of it, when it was described on this big sheet that y'all shared with everybody, was them laughing about the drinks murder.
Right. And I have that happening at 4 minutes and 20 seconds into the call. So and I'm not saying Ms. Hilton's wrong, maybe this call isn't that long, but the parts that you wish to play, can we just play it?
Yeah.
Because there's a lot of confusion.
Okay, because then I guess the part about the drugs comes after all of this. Okay, all right. Because I definitely wrote down that there was something about, y'all said there was a non-hearsay purpose and you wanted to show something about flipping the car and laughing, but if y'all aren't gonna get into that anymore, then that's fine. And I think this one and the one before reference a quay, and understandably, there's some concern about confusion. Is it gonna be clear?
And I'll apologize. I must have listened to 512, which is the 2 minute and 40-second call, because they talk about drugs in that call as well. But it looks like I was supposed to look at the call under
The one at 9:41 p.m.
Of course, indulgence for one moment.
No, that's the 502 is also 512, and that's talking about Big Nick's. And that one also says something about not having to drop on people. But we ruled that one, or I ruled that one could come in. But there was a concern about whether we need a 105 with regard to quay or qua, which I'm happy to consider.
On call at lunch, I listened to the 2 minutes and 40-second call, which is the call right above it. If we could have
the one that says 502.
Yes, Your Honor, at 6:49. If I could have a brief moment, I can listen to the correct call, Your Honor. So that I apologize.
Okay. Only other one we had talked about but not made a decision on was the nested hearsay one. Do we need a quick break? Why don't we all take a quick break? 10 minutes.
Hey, everybody. Thanks for stopping in. We're on a break. I haven't talked much because I'm trying to catch up on my work in the last 2 weeks being off. Oh, I hope you can hear me. Check. Yeah. Okay, so if anybody care, I had a great vacation. I'm glad to be back, kind of, but I enjoyed myself. I went to Jamaica and I got back Sunday night. Monday, I had braids. I took them all out, washed my hair and everything. So here's looking a little dry right now. I'm gonna get it done so it'll look better. Hopefully soon. Good night. See you tomorrow. Me too. But let's check out somebody's page who might be talking. Usually Cat Williams. Okay, here we go. There we go.
So Tucker Davis says, I take it back. He actually did it before he got up. What do you guys think?
Any social media, anything about this case or anybody that's involved in it. Media coverage, any social media, anything about this case or anybody that's involved in it.
What do you guys think? What do you guys think? And I don't know if there's anything else. Shout out to Marlena Mack. I see her in here. Okay, what do you guys think? He did it on purpose. It looks natural, force of habit. I don't know, sometimes now I'm nervous because sometimes I like go like this. I don't know. Now you guys are gonna be like, she's doing the thing. The thing. Well, sorry, this is just a clip. So I know you guys did call out like other people in the courtroom doing the nose. I wipe my nose like that. Habit, coincidence. He used to doing it. And I don't know, every time I have a StreamYard thing, videos just don't want to work.
Any social media, anything about this case or anybody that's involved in it. Media coverage, any social media, anything about this case or anybody that's involved in it. Media coverage, any.
And I mean, he's already kind of doing in my opinion, he's already doing the facial expression before he turns to look the other way.
Social media, anything about this case or anybody.
Was this just right after they were like ready to break for the day because he was getting heated? Because I would be making that face on the stand too. So where he was being a smart ass. Oh, so guys, we did, the amicus curiae, that was a long time ago. It's 28 pages. I'll link to it if you guys want to read it, but that is not new. And then the other thing we read in the middle of the stream today. So this is the amicus curiae. So in support of Brian Steele. And you guys are asking to go through this brief from the state saying that they don't want to be part of this, argument that Brian Steele is bringing forward in the Georgia Supreme Court. We read that earlier today, but here's the link if you want to be able to read it, or you can rewind on the stream and find it. It was like 3 pages there. So there's that for you. Other than that, I think that was, the extent of the updates here. I think that's clears anything that Thugger Daily was talking about. But yeah. Yeah, in either case, if he's being slick with it, if he's doing it on purpose, I mean, the state called him as a witness. That's my opinion. So the state can have fun with their own problem. Like it's their witness. It is their witness. So they, oh, and I guess if you guys want the link to that clip. So this is the nose clip. So there you go. And while they're doing this recess, again, thank you so much for the generosity, really for everyone, between the gifting and the super chats. And I've got this one here that I've been waiting to laugh with. Want to make sure I don't say laugh at, because I don't mean it that way. But Steven Satchel says super chats were blocked too. So while YouTube had its kerfuffle, everyone thought that they were like banned, that their account got banned. It wasn't even letting me. Coincidentally, I was trying to send a link to the chat, and I was like, well, maybe there's just an issue with sending links right now. So I pull up my phone and just try to say, hey, to the chat from my phone, and it's not sending. And then finally it sneaks one through when I'm trying to say, I think the chat's not working. And then a few of you snuck it through. We figured it out. But I felt like I did something to get banned from commenting in my own chat. I was wondering if you guys felt like we locked you out when we did it. And it was just YouTube having a hiccup. But Steven Satchel is like, super chats were blocked too. So thank you for sending it too. Like a test to make sure super chats were working. Super, super supportive of you. Penny G says, so the lying paper counts. We're talking about the plea deal back in this morning. The lying paper counts more than the lawyer testifying. If so, what was the point of calling the lawyer to testify? Penny G, I don't know. I don't know what love would be satisfied by. You want to use a plea deal against these defendants, then the plea deal gets dismantled by your own witness. Then you call that witness's attorney, who kind of supports his client's interpretation of things and the circumstances of which he was under. And now you're mad about that. So now you want the jury to be able to read all your versions and iterations that you think help you. Just produce the signed proffer, right? It'd be awesome if you had a signed proffer. You know, these are ideas, statements, acknowledgments before they're acknowledgments. These are statements, versions of events coming from Sledge himself. Produce that. You haven't produced it. Why? Shout out to Penny G. Michelle says, he was impeached. Why would any of the evidence from him be admissible? Now, just because someone's impeached doesn't mean that evidence from them or involving them wouldn't be admissible. In fact, impeachment is a way that things that ordinarily wouldn't be admissible could become admissible, depending on how the judge rules and what the reasoning is. So for a shocking amount of this case, honestly, and remember, we're all in the state's case in chief so far. Every witness that has been called by the state. And there's been several times they have impeached their own witness to be able to introduce things. Now, there are some states, Georgia is not one of them, but there are some states where you're not supposed to be able to call a witness for the purpose of impeaching them. And I'm not sure how much that actually holds water, because the state could say, look, we know that they might not be consistent about this one thing, and we're not going to ask about that topic, but we still want to call them to talk about this, and then somehow veer off and still ask about that impeachable thing. But in Georgia, that's not a issue. They can call a witness and impeach their own witness. So it'd be very interesting to see how this case played out in another state because of that alone. Thank you, Michelle. Good opportunity to talk about impeachment. Touche says, a state is mad because Sledge admitted he signed their words without agreeing. Just completely dismantled what a plea agreement might actually mean. And the irony of all of this is happening after Love read the factual basis for an Alford plea onto the record. And now when we have the actual guilty plea agreement factual acknowledgments, the state is still mad because Sledge poked holes in that too. So Touche goes on and says, then gave an explanation that the jury and us understood and seemed credible. Plea is useless, Miss Love. You're bad. Move on. Yep. And we spent several hours today because Love cannot move on from it. KC Dog says Miss Love is the real life Frankie and Alice, the Halle Berry character. That would explain why some of the stuff goes on and on. Steven Satchel says, looking to the future, defense should cross each plea deal witness about the process and whether the attorney was able to edit the document directly. I'm actually surprised we didn't get much pushback today, guys, if you tuned in late. If you tuned in late earlier in the day, the one of the arguments and something that got addressed The judge thanked the state for turning over email correspondence with other attorneys that may have been involved in plea deal negotiations. And I didn't really hear pushback from the defense, but maybe they didn't have time to go through it. Maybe they just got it. And the judge wanted a hard copy of it. So I am curious to see if there's some pushback from the defense. You know, it seems like we didn't get everything, or we're curious if there's more. Because when Love said she produced everything from correspondence between herself and Derek Wright, she was only producing like her final response, the thing that she sent to him. She wasn't actually producing the full correspondence. So I don't think we've closed that chapter on whether or not Love turned that stuff over. I think we'll hear some more. But yeah, the Doug and then I think Adams brought in Doug's request. We're on this. They said, look, we want the discovery. We want any communications correspondence for witnesses you plan to call. The problem for someone like Durante Beebe, who took a plea, the prosecution, at least back then, said they don't plan to call him when this case goes to trial. So I wonder if they actually were able to get email correspondence in that regard. It'll be interesting to hear, and we won't know until we know. Thank you so much. Apunanu says, can we just send Doug our notes? Heck yeah, guys, Doug is very active on X. You guys saw him in the chat earlier. If there's something notable to get to Doug, I think he is tuned in with the things people are saying, common sentiments, information that people unearth and send forward. Very, very responsive. So make sure you give Doug a follow if you're over there on X. Finding Good jumped in and said someone's going to become a Cat Chat RICO gang member today. Thank you so much, Finding Good. Gwennon, I had read this earlier, but it still rings true while we're dealing with some of these social media posts from Durante Beebe and Christian Eppinger. Now, Christian Eppinger, I don't think took a plea. He's just severed. He's still waiting trial, I believe. I could be wrong. I lose track sometimes. But they're Beebe and Eppinger. The point is they're co-conspirators. So that's why there's some exception that they're trying to get this social media stuff in that's apparently publicly posted. I'm not convinced, but we'll see. But the judge is just like, I'll admit it for now and we'll figure it out later. Well, why don't you make the party that's trying to admit it meet the burden to introduce it? If they're saying that something is something, ask who the expert witness is that they plan to establish whatever they're asserting. We have an expert that we're going to bring in that will show this. Don't just let them say, don't tell them you should bring in a witness and accept their response. Oh, we will. Do they have someone already? Work it backwards because they've already made the assertion that they know how this was posted. That's a big thing that's driving me nuts today. Shout out to Gwennon. Judge, we'll deal with it later, Whitaker. W for we'll deal with it later. Positive Q says, it seems like the judge wants a guilty verdict. Take it up with the appeals court. Take it up with the appeals court. Seems that we need an easy button. Let's take it up with the appeals court. You guys were loving Shart earlier. That was great when he finally interjected. Apunanu says, Shart, we're tired. Touche says, Shart is all of us. Shout out to Shart. That was a great moment of the day. It broke the monotony. L. Allen became a member. Thank you for joining the gang. Chloe Albert's Revenge loves Mike. I'm melting. I'm melting. She was so happy to get other batteries. She was really ready for that. Whew. Stephanie Lane says, Kat, I just want to thank you for working, period. No problem at all, you guys. Appreciate you guys for being here. I would not be doing this if you guys didn't make me laugh. I would not be able to do it without the chat. So thank you so much, Stephanie, for the kind words. And then Lying Love is wiggling because her butt's itchy. No, she's itching to get up and talk constantly. Touche says, how are the citizens of Fulton County not protesting in the streets? If this trial is what goes on, who gets justice there? And what I think is kind of a decent question here is, I'm in Florida. I'm very lucky that a lot of our cases are televised. I think we have good enough transparency, relatively speaking, to systems in other states. But with this, I think it's really interesting that it is televised. There's so much attention on it. And I still just don't really see this covered in the major outlets. I don't know if it's because of the complexity of the case, like an outlet like USA Today or something like that doesn't want to and expend a journalist who would really have to start covering this full time. But I really see a lack of coverage at the national level about this case. We get things once in a while, but it's incomplete, and it's a very bare bones top level look at things. It's really the local outlets that are raising awareness. So while there should be some pressure for local action, Fulton County, I do wonder statewide, state of Georgia. The state of Georgia, a lot of funding comes from the state to Fulton County. The DA writes budget requests and makes presentations to request more money from the state. And I'm not boots on the ground in the state of Georgia, but I wonder what the awareness and the reaction and the sentiment is when we consider the rest of Georgia outside of Fulton County in this case. And I don't know if the chat wants to chime in, anyone that's got boots on the ground insight there. But it's always an interesting question to me. What does the people of the whole state think? So good food for thought, Touche. I'm going to toggle over to the chat. Do we have any Georgians in here? Georgians? So, and like, this is really like kind of what I'm getting at is, what if the state decides to pull some of the funding or have a strict hand? If there's a risk of the budget being trimmed or constrained, that actually puts some fire under people's butts to do the right thing. So, okay, cool. Look at all the Georgians. Look at all the Georgians. Okay, and Otto says I'm outside of Georgia, but people don't really care outside of Fulton County. And that's really what I'm wondering. Jay Smith is in a different county. Sweet Peas in Georgia. Cobb County, Southeast Georgia. DeKalb. Before this trial, I was like DeKalb County. Okay, so MKWN says Fulton is always the outlier. So I think that's really interesting. I think some of the bigger change could come from pressure from the rest of Georgia on Fulton County and for what they're doing because of statewide budgetary concerns and issues and deciding how money's going to be spread. So really, I think one of the best avenues for pressure might be right on the outside. So I don't know. But that's sometimes, I used to live in Rochester, New York, and Monroe County, the city of Rochester, we've gotten our finger wagged at Rochester County or Monroe County because of budgetary concerns dealing with the state budget. And it seemed like it got some people into gear. So I'm wondering if that could be part of the solution.
3 minutes.
So we are back.
I'd just like to recap, if we can, before Ms. Hilton. Can we recap where we are just for a second?
Sure.
You
And
can
there
help
she
me
is.
with that, please, Judge. My notes from our previous sessions said 513 was open, 624 was open, 806 was open. The state today said 1109, and I'm going from the reference numbers. They weren't going to try to get that in. Was there a ruling on 513?
That's what she needed to go back and
Okay.
listen to again. So that's what we're about to hear from her, whether she's narrowed.
Okay, great.
And then, okay, so read those out to me again.
All right, 513 we're going to deal with right now.
Yep.
624. I had that, my notes reflect that was open as well.
What,
Open meaning you hadn't ruled
we
on.
haven't,
Yeah.
yes, agreed. That's the one that's the nested hearsay, right?
No, the nested hearsay, well,
Oh, okay.
it nested hearsay was 2119. That's on the next page.
Okay.
At least that's the one that.
Yeah, you're right.
So I'm trying to
So
figure
what
out
else? So 513 slash
624.
6, which is also 635. It's very complicated with these
Yes,
two different numbers.
806 and 820.
806, yeah,
I had,
you're right. I have a note by that, both of those that said
So there's no-
tomorrow, which we apparently never
Right.
got to that
so
tomorrow.
there's no ruling on those yet?
Correct, no
Okay.
ruling yet. And on both of those, if somebody from the state could listen, I think the question for both 636, I don't know which reference number's which, but 624/635 and then 806/820, I think, was who is the other talker? That's what we were waiting to hear back on. But yes, that matches up with what I've got as well, Mr. Harvey. All right, so if you're ready on the 513, 523 one, we can do that one.
So I can answer the 624 and 806.
Okay.
We just know right now there's a person named Unk, but we don't know who that person is.
Okay. Name, what's the first name?
Unk, like they call him
Unk, okay, which y'all knew also, and they don't know who that is. And so are y'all asserting that Unk is a co-conspirator, or you have no idea?
No, we're not going to start because we don't know who. Unk
Okay,
is.
and so then is there some other basis under which you're asserting those two, whatever they are, conversations could come in? Okay.
No, 624, 806.
You think that they would be ready for this? Love is ready to take over. Love is going to take the microphone. Shout out to Mark in Texas. Pippi, the dog, swears he heard Glanville's dog. Oh. Yeah, probably just a little chair squeak. Hilton's chair squeak is a bit more muted than Love's chair squeak.
All right, everybody. Thank you again for stopping by.
Correct. There's an L3
Gotta
Harris.
get ready to
Actually,
leave.
L3 Harris pretty close
So
to me.
we'll do it
And
again tomorrow.
a bunch of companies.
Night.
But I do run into people a lot of the time when I hear from someone's from Rochester. They worked for something like Kodak or L3 Harris and then came down
Going
here.
to sorting through the evidence.